we would encourage you to conclude your submissions on response to Mr. Otti's case within the time frame that you were originally allocated, so that the extra hour which you've got, I think, in effect between 12 o'clock and 1 o'clock, should be used only for the human rights point. That's what you asked the extra time for, I think.
Yes, yes. Having reviewed the position overnight, looking at the questions that were posed to Mr. Otti yesterday by your Ladyship and your Lordships, and seeing that the focus needs to be on some of those, on all of those matters that you've raised quite rightly as being central. Time may be taken up on those more so than I had anticipated. In other words, if I'm left with, if I may use the time that I have beyond 11 o'clock, if I haven't got to dealing with...
Well, it's beyond 11. I think you
12, sorry, I beg your pardon.
12, yes. You've got 2 good hours this morning, both to deal with our interventions and Mr. Otti's submissions.
Well, I shall rise to that challenge, my lord. Well then, that shall be the aim.
Yes.
Can we, if I miserably fail in that by any measure, do I still have the extra hour to deal with any points that I still have to deal with in response to Mr. Otti, sacrificing that for any time that I might otherwise have had to deal with the UNSR's position?
No, that's what I was hoping you wouldn't.
Yes, there is quite this side of the room has the benefit of more supporting authorities than Ms. Wong's case, and so there is a plethora of material to deal with. Fortunately,
but we would have read a fair bit.
Fortunately, it's addressed in the written
time
case.
to read a fair bit more of it when we've all finished the oral hearing.
Indeed.
I'm sure you understand that.
Could I then say then that I'm going to have to advance the submissions at some pace?
Yes.
Obviously subject to dealing with any interventions. And I shall deal with it in the structure that I proposed yesterday.
Yes.
Confident that you'll have digested the written cases that we've submitted. And what I purport to do is signpost you to the references in the written case at each juncture, making my own spontaneous judgment calls as to where I need to slow down and where I need to speed up. But there are some matters that might slow us a little down of detail that I need to take your Lordship's Ladyship to, and I'm not entirely certain how long that process might take. But
please understand, we continue to be interested in your answers to the questions which we've raised.
Absolutely, and that's a priority for me, my Lord. Right, without further ado, the scheme of the VCDR, there are 2 points we wish to stress here. The first is the reciprocal nature of the immunities provided under the VCDR and diplomatic relations in general. That is central to the operation of the VCDR. I cited yesterday the Barnett case at paragraph 50, page 1676, where the FCDO described them as one of the most valuable elements of the VCDR in practice and one that is rigorously upheld by the UK, even in times of crisis. In many respects, my lords, diplomats are the hostages of the receiving state who may be subjected to countermeasures by way of reprisal or on a preemptive basis if the sending state does not comply with its obligations under the VCDR. And I would point you to Lord Sumption's judgment at paragraph 12, subparagraph 4, at page 872.
Yes.
And what I shall do in some cases, I shall take you to the citation in order to ensure that the emphasis is appropriately made. In others, I'll simply give you the citation. That's page 872. And your Lordships will no doubt slow me down, as will your Ladyship, if I'm speaking too fast. At 872, paragraph 12.4, Lord Sumption stated that every state to the Convention is both a sending and receiving state. The efficacy of the Convention depends even more than most treaties do on its reciprocal operation. He refers to Article 47.2 of the Convention, authorising any state, receiving state, to restrict the application of a provision to the diplomatic agents of a sending state if that state gives a restrictive application of that provision as applied to the receiving state's own mission. In some jurisdictions, such as the United States, the recognition of diplomatic immunities is dependent as a matter of national law on the reciprocity, and as Professor Denzer observes, for the most part, failure to accord privileges or immunities to diplomatic missions or their members is immediately apparent and is likely to be met with appropriate countermeasures. And he says, I beg your pardon, in the graphic words of her introduction to the Vienna Convention on the United Nations Audiovisual Library of International Law website, a state's own representatives abroad are, in a sense, hostages who may, on a basis of reciprocity, suffer if it violates the rules of diplomatic immunity. The US response also addresses this point. My lords, I should give you the...
Is this of any relevance here? The UK is not exactly going to be upset if foreign states allow British diplomats who engage in human trafficking to be sued in civil proceedings.
But it's not just human trafficking. They may well construe other matters by way of reprisal if inroads are made in a way which does not meet with...
There's no evidential basis for that assertion.
Well, my lord, if one looks at the FCDO submissions, their interventions, both in the Court of Appeal in race and in the Supreme Court in race...
I did read those last night after you referred them. There's nothing there suggesting that the UK would be perturbed if this commercial activity were construed as including human trafficking.
Indeed, you'd expect our government to take action.
Give me the references in the Court of Appeal straight away, page numbers.
Against one of our diplomats.
The submissions that the FCDO made to the Court of Appeal and the Supreme Court in race, which was on not materially different facts in this case in terms of the employment of a trafficked migrant domestic worker, raised the very real risk and concern that they had about countermeasures being meted out to our diplomats abroad as a very real reason for not adopting a unilateral interpretation of Article 31(1)(c). I'm just going to go to the passages in those two sets of submissions.
I'm not sure that Mr. Rotti is asking us not to adopt a universal interpretation. He's simply saying that on his submission, a universal interpretation strictly in accordance with the Vienna Convention on the Interpretation of Treaties produces the result for which he contends.
Which he contends. Well,
I appreciate that the second intervener may be taking a more rigorous line, but we're not there yet.
I agree. The difficulty, in a nutshell, that Mr. Otti has on his analysis that the ordinary interpretation of the words in 1961 accords with his interpretation and would be met, he would say, or seek to persuade you, with global acceptation by the contracting state parties in 1961, as it would today. The difficulty with that is that all of the unanimous view of the Court of Appeal in race and the unanimous view of the Supreme Court in race, including Lord Wilson, Lady Hale, was that they were sure that, as at 1961, the contracting parties did not intend that the current set of circumstances would be covered. How does he get over that? He doesn't. We have the most persuasive dicta. It was binding until the Court of Appeal were overturned, and it's certainly highly persuasive in the Supreme Court in race. All of them, the one thing they all universally agree on, the one thing, is that, as at 1961...
And how did they arrive at that conclusion when the matter wasn't even discussed?
My Lord, I'm not sure I understand the proposition that it wasn't discussed.
The concept of modern slavery, or indeed slavery at all, wasn't discussed in the preparatory works. Oh. So how do they arrive at that conclusion?
Because there will be lots of matters of detail which were not discussed in the negotiating stages of this multilateral treaty. Modern slavery may well be one example. Works of the internet might be another example. cryptocurrency or something else which is a modern development. But that doesn't assist the position that we're currently in, which is that the point I've just made, which is that the stage we are at here is that we have emphatic dicta from the Court of Appeal unanimously and from the Supreme Court unanimously in race. Unanimously. And the one thing they are, to say, certain and sure about is that the drafters of the convention would not have envisaged that slavery would be trafficking of a domestic migrant would be caught. And can I just deal with the point, Lord Stevens, that your Lordship has just made? I understood Mr. Ottie's submission to be that slavery is not a new thing. It was there in 1961. It's been there for centuries. And so that is a basis, and the fact that there are pre-existing anti-slavery treaties that he took your Lordships to in your Lordship yesterday, is the premise for him saying that they can be taken to have had those matters in mind in 1961.
The concept of slavery has evolved. The 26th definition is ownership, and which leads me on to a separate question, and that is, would ownership be a commercial activity? So that if you acquired a slave, would that be a commercial activity?
This, my lord, goes to the commodification of humans argument that my learned friend raises. Well, and of course, what on that basis is happening is that you are a purchaser of goods or services. You're a purchaser of a human being. It is a purchase transaction. It is a business to consumer transaction in one sense. If it is not in the course of business.
Doesn't that slightly cover up what really is going on with it? I mean, I understand you to be contending that the purchase of a slave isn't a continuous activity.
Indeed.
It is just a one-off act. Is that right?
Yes.
So that you own somebody.
Well, the purchase is a purchase. The purchase is a single act. It's a single event. It's not a continuous event. You're not continuing to purchase. You have purchased. If you obtain ownership, at the point in time at which ownership is crystallized is when the purchase is concluded.
I think you then say that the exploitation of the slave is not a commercial activity. That's your contention, as I understand. That
is a really important point, my lord, which I really do want to develop in a moment, and that is that trafficking. There's a big question mark here as to what is the commercial activity in this case, on the assumed facts. Is it trafficking as defined under the Palermo Protocol, or is it something else? Is it some other? Is it something else? And is that something else the exploitation? And in this case, it might be domestic servitude. But domestic servitude is not trafficking. Trafficking requires a key component of an intention to exploit. It doesn't require exploitation for trafficking to be established. I shall take you to the basis for that in a few moments. The exploitation, in this case, which has been pleaded, relates to subsequent mistreatment during employment, underpayment, being abused, locked up, that sort of thing. So there is an assumed fact in the case of exploitation, but that is not trafficking. And I do want this point to be nailed, for want of a better word, at some point.
I'm really worried about taking you out of your course, Mr. Sedley.
Yes, you are.
We will want you to nail it in due course.
And I do want to.
But I'm troubled we're going miles away from your current line of approach. I'm not blaming you. You're responding fully and fairly to our questions.
So the first point was the reciprocal nature of the convention. The second key point I just want to deal with at this point is that the VCDR is a self-contained regime. It's a self-contained regime of privileges, of immunities, of narrow exceptions to immunities, of prohibitions and or sanctions for breaches. And you have those submissions set out in our written case at paragraph 24 and in the Barnett case, page 1677, paragraph 52. So, for example, the sending state can ask the receiving state can ask the sending state to waive immunity under 32(1. The receiving state could declare the serving diplomat persona non grata under Article 9. It can restrict the size of the mission under Article 11, and it can exercise a nuclear option or closing the mission under Article 2. So those are the two observations on aspects of the VCDR regime which I wanted to just stress at this stage. One point I want to deal with is slightly out of sync, but it just deals with the outlier example of the Portuguese situation. The appellant, we say, is wrong to rely on Fonseca, which is at page 4082, in order to override policy concerns about the position of British diplomats. And that's really for the following reasons, because he's asking this court to assume that there's no problem with the Portuguese situation. But when the reality is there is no evidence before your lordships and your ladyship from the Portuguese government or otherwise to the effect that the stance that the Portuguese are taking has not been met with reprisals and countermeasures and problems for their diplomats abroad. And the other problem with the Portuguese case of Fonseca is you really cannot, and it is the only outlier here, you can't give it any material weight, and that's for three reasons. First, the Supreme Court of Portugal didn't even specifically construe the commercial activity exception in Article 31(1)(c). We deal with that in our written case at 57 subparagraph 4. They didn't even address the preparatory work to the VCDR. Secondly, thirdly, they proceeded only on a domestic law principle of construction under Portuguese national law. And fourthly, they proceeded on an analogy, an inapt analogy with state immunity, which, as Lord Sumption says at paragraph 33, is difficult to support on any generally accepted principles of international law. So we say the Portuguese court incorrectly described the scope of diplomatic immunity. They concluded that immunity didn't extend to acts that were not practiced in the name of the sending state for the purposes of the mission. But the Fonseca case is not reliable either as a matter of law or as a matter of policy. The evidence isn't there. The evidence that you do have post-Fonseca, which is supplied by the FCDO in the Court of Appeal in Rees and to the Supreme Court in Rees and by the US State Department response to the workers' petition, observes these problems with Fonseca. So you can see that despite the Portuguese, it may appear to have no problem with the situation, the US, the UK government still perceive the problem is very, very, very real. Further, the appellant's assertion that adopting the same approach as the Portuguese court would not create undue difficulty conducting international relations is not really of any comfort. The FCDO's evidence quoted in the Barnett case, my lords, the reference is page 1677, paragraph 54, is particularly instructive.
Sorry, what page did you give us?
1677.
Oh, I misheard you. Thank you.
But we deal with this in our case, our written case, at 20 to 21 and 45, subparagraph 3. But at paragraph 54, we have in that case the judge observing that Ms. Macmillan also anticipated that any unilateral change to the scope of the VCDR's privileges and immunities would substantially impair FCDO's overseas work. She expected that the risk of reprisals or reciprocal restrictions would materially affect the confidence with which our diplomatic staff carry out their work and possibly their willingness to serve the UK abroad, particularly in riskier environments. And as I say, the US response considered the Portuguese Supreme Court's solitary view, but remains deeply concerned about the real risk of countermeasures. And the reference to that, my lord, so that you can see it in your own time, is 5273. And the FCA, in its submissions to the Supreme Court in Reis at 5621, paragraph 11, emphasised quite well the principle of what is sauce for the goose is sauce for the gander in this context, and it is treated as such by foreign states when they observed at 5621 Paragraph 11, whilst it is tempting to assume that there is no good reason why Miss Rees should not be able to bring her claim before an employment tribunal, after all, the employment tribunal is an independent court, and if the claim has no substance, it will be dismissed, the same cannot be assumed of every legal system in every state. Furthermore, diplomatic community operates on the basis of reciprocity. What is sauce for the goose is sauce for the gander. The court must therefore bear in mind that if the protection granted by the VCDR is eroded or restricted in this jurisdiction, then the same limitations may well be applied to UK diplomats abroad. Now, my Lord, moving briskly on, what I now propose to do is to move on to a proper interpretative approach to the VCDR. The first proposition is this, of primary importance to this appeal, that the VCDR must be given an autonomous international meaning of universal acceptation rather than a domestic parochial interpretation. However well-meaning or potentially acceptable to that particular state, that in parochial interpretation might appear to be.
I think you say also not a regional one.
It's the point, yes, not a regional one. Yes, so not even just sole state specific, not even a regional one, but at a European level, say, or between a set of Arab states, or on any continental level. It's got to be, you have to be confident that it would be universally accepted by the state parties to the UN Convention. And that is what is meant.
I'm not sure one can be confident it will be universally accepted by the Supreme Courts of 190 different nations. And we already know that Portugal and the USA don't agree on a closely related question.
Right.
So how can one be confident that if we say that on a difficult point of interpretation, right at the fuzzy edge of a definition,
yes,
we think the answer is X, we're sure every other state in the world will agree?
And this is precisely why, my Lord, Lord Wilson himself, at the ultimate conclusion in Rees in the Supreme Court, the best that can be done is to express doubt, is to indicate what other feasible potential interpretations there might be.
Well, he was expressing doubt. That's right. I was going to say he was expressing doubt because the point didn't arise for decision in his case. But if it had arisen for decision, surely Lord Wilson would have had to decide the point.
Yes, he would have had to decide the point.
There's no principle that I'm aware of that says that you must search for an interpretation that everyone else would agree with. The requirement of an international interpretation is that you apply the international interpretive rules in the Vienna Treaty and not our domestic rules of interpretation.
Absolutely, my Lord. But
we might reach a result that isn't generally accepted, but that's a risk of any legal process. We're considering what we think is the best international interpretation, as best we can.
The best international interpretation can only be that which meets the test of in answering what is the common international intention here between the state parties.
Yes, but that's not, well, that may be their putative intention in enacting the Vienna Diplomatic Treaty, but that's different from what they would generally accept across courts around the world. You're not suggesting that's the test, are you?
No, not at all. Not at all, my Lord. It is, perhaps the language was momentarily there loose, but the point is you're searching for the common intention. But the common intention in a multilateral treaty is the common intention across the board of all the contracting parties to that instrument. And that search for the common intention, that process, is one which is dictated by the VCLT. And a domestic court should not, and actually let me just make one other sentence, another proposition. International treaties can only have one meaning. So that's what you're looking for.
Well, so can contracts, but it doesn't stop
Any document you interpret is treated as only having one true meaning.
But it's one true international common meaning. The domestic court, a domestic court, a regional court even, should not depart from the natural meaning of an international treaty unless the finding is that the departure plainly reflects the common intention of the other participating states, so that it can be assumed to be equally acceptable to them all. And that's what Lord Sumption says in Rees at paragraphs 12.1 and 12.2. Correctly, in my submission. So just very briefly, 12.1 and 12.2 will be a paragraph that you're familiar with, of course. This is where the point is made, where he says, in the case of the Convention on Diplomatic Relations, there are particular reasons for adhering to these principles. And he says, one, like other multilateral treaties, the text was the result of an intensely deliberative process in which the language of successive drafts was minutely reviewed and debated, and if necessary, amended. The text is the only thing that all of the many states, party to the Convention, can be said to have agreed. The scope for inexactness of language is limited. And then he says at subparagraph 2, the Convention must, in order to work, be capable of applying uniformly to all states. So that's really the point I was making about uniform application and acceptation. The more loosely a multilateral treaty is interpreted, the greater the scope for damaging divergences between different states in its application. A domestic court should not therefore depart from the natural meaning of the Convention unless the departure, as I've said a moment ago, plainly reflects the intentions of the other participating states, so that it can be assumed to be equally acceptable to them. As Lord Slynn of Hadley observed in Ex parte Aden, an international treaty has only one meaning. The courts cannot simply adopt a list of permissible or legitimate or possible or reasonable meanings and accept that any one of those, when applied, would be in compliance with the Convention. And that's why I stress it only has the one meaning, and why I stress it has to be one that would be capable of universal application across the world in every state. The other reference that should be made is to the torture case of Jones at paragraph 63, page 2365. So 2365. It's towards the end of that paragraph on internal page number 298, B to C, where Lord Hoffman observes, but the same approach cannot be adopted in international law, which is based upon the common consent of nations. It is not for a national court to develop international law by unilaterally adopting a version of the law, which, however desirable, forward-looking and reflective of values it may be, is simply not accepted by other states. And concurring with the opinion of judges in the Al-Adani case. The next point to observe is that in this single set of rules of interpretation that is provided in Articles 31 to 33 of the VCLT, it is a single self-contained interpretive exercise. It's to be applied, the steps are to be applied simultaneously, holistically. The court must keep open the correct interpretation until the interpretative process has been completed and all elements of the Article 31 to 33 process have been evaluated together. It is, as my learned friend indicated, a process of progressive encirclement, it's been described as, or a process of throwing all the relevant factors into the crucible, or the crucible of treaty interpretation, as the process might be called. We deal with this in our written case at paragraphs 27 to 31. The process of interpretation does not conclude with the application of Article 31. It's always possible and always permissible to use the preparatory work and refer to the preparatory work to the treaty to confirm the result. And that's Article 32. The appellant is wrong in this case to state otherwise, as they have in their written case at paragraph 77 to 78. The very aim of the interpretive process is to ascertain the common intention, and this court must strive to give Article 31(1)(c a desirable, the court must not strive to give it simply a desirable interpretation which undermines those intentions or the VCDR's object or purpose. And we deal with that in our written case at 32(1) to 32(3). My Lords, if I might turn swiftly to the correct interpretation of Article 31(1) by the application of looking at the ordinary meaning in context and looking at object and purpose. Lord Sumption in Rees correctly undertook this process of interpreting an action relating to any commercial activity exercised by the diplomatic agent in the receiving state outside his official functions by considering those three aspects: ordinary meaning, context, object and purpose, before going on to look at the preparatory work. And he confirmed his interpretation by reference to the preparatory work at paragraphs 34 to 38, as we know. That's at pages 881 to 883. We deal with this in our submissions at paragraphs 38 to 39. He rightly concluded that the employment of a domestic worker did not amount to carrying on or participating in carrying on a professional or commercial activity. And it was the employment and treatment of that worker, which is important in that case, didn't amount to a commercial activity. Can I deal with ordinary meaning? Jumping straight into that pit. There are two observations that need to be made here, one by reference to Lord Dyson and one by reference to Lord Sumption. The construction of Article 42. Article 42 does not say that diplomats shall not engage in any activity for personal profit. It specifically prohibits turning a profit in the course of a business activity. It's business activity, a commercial activity for personal profit. So it's the for personal profit cannot be analysed in isolation. It's part of the commercial activity there. It is the business activity which must be for personal profit. Later, when we apply the ordinary meaning to the assumed facts in this case, then the court must ask itself, what in those assumed facts is the business activity carried on by Mr. Basfar generating a personal profit? And of course, we'll come to the debate as to what personal profit means, and we're assisted in that by encircling into the travaux préparatoires and understanding what the draft has meant by profit in that article. The next point to observe is to go immediately to the Lord Dyson's analysis of ordinary meaning in the Court of Appeal. And just before I do, I add that when one looks at the dictionary definition of definitions of commercial or commerce, as a starting point perhaps, commercial means concerned with or engaged in commerce. Commerce means the activity of buying and selling, especially on a large scale. And what might flow from that activity is profit. But profit is one manifestation of the commercial activity. It is not, my lords, my lady, in and of itself the commercial activity, because you can have commercial activities not generating personal profit, as we'll see in the travaux in a few moments. And it's worth, therefore, in this context, when looking at the ordinary language and the ordinary meaning of the words, commercial activity, to see what Lord Dyson emphatically held, with which he was supported by the rest of the Court of Appeal, of course. This is page 838, paragraph 34. In an important passage in this section on ordinary meaning.
We have to bear in mind, don't we, that Lord Dyson is treating it as a composite phrase, namely commercial activity outside the employer's diplomatic functions. And on his overall conclusion, there was a unanimous departure in the Supreme Court on the last part of that definition.
Only on whether the employment of the domestic worker was outside or inside the official functions.
It's very clear that Lord Dyson was looking at the phrase as a whole, as indeed perfectly properly.
And indeed, as he ought to be, because that is precisely what one does, and which is what your lordships and your ladyship will do. But that doesn't detract from the point I'm about to make here, which is that when analysing the ordinary meaning of commercial activity, his words are apt. He refers to, yes, and being reminded, of course, that in the Supreme Court, their finding, my lord, on official functions was obiter.
That's not susceptible of a lot of analysis what something means as a matter of ordinary language, but I think it is relevant, isn't it, that in the different context I accept of state immunity, and I take your point that different principles apply there, but nevertheless, as a matter of ordinary language, courts in the United States, Canada at least, have found that employing a domestic worker is a commercial activity, is a matter of ordinary language. And indeed, I think the court said that in the diplomatic context, the American court, in the case we were showing yesterday. So simply as a matter of ordinary language, I find it difficult to see how you can say it clearly has the meaning you contend for when various highest courts have said as a matter of ordinary language it can mean something else.
But, my lord, the highest courts in law lords in this country, if we make this as a starting point, Lord Dyson, then Master of the Rolls, and also Lord Sumption, take an emphatically clear position on this.
Well, how do we adjudicate between those as to what the ordinary language is?
Well,
we've got two different.
Because I invite your lordships and ladyship to adopt the analysis and to analyse this analysis I'm about to take your lordships to and ladyship to. Paragraph 34. So he says, even if the claims relate to trafficking, the question remains whether such claims relate to a commercial activity. Yes, outside the employer's diplomatic functions is part of the test. I shall assume that Chilean are right when they say that intermediaries from informal labour brokers to registered employment agencies generate vast profits, both from employers and from migrant workers themselves. And two, he says this, employers benefit, notice the word benefit, they benefit financially by paying sub-market wages, demanding unlawful working hours, and by levying charges and withholding benefits to which workers are legally entitled. But these features of the trafficking industry do not shed light on the question whether a particular diplomatic agent who employs a particular trafficked employee to carry out domestic services at a mission is engaging in a commercial activity. So he's squarely focusing on the ordinary meaning and his construction of the ordinary meaning of commercial activity within Article 31(1)(c).
You're asking the wrong question. He's focusing on the activity being employment as opposed to the activity being trafficking.
I need to deal with the point about, it seems to me that my learned friend's submission is that it was the employment is the trafficking, or the treatment during the employment relationship is the trafficking. But
the case is based on trafficking.
Indeed. And
that question is different.
Well, he says even if the claims relate to trafficking, the questions remains whether the claims relate to a commercial activity. So he's not ignoring the trafficking dimension there.
But asking the wrong question, potentially.
I would beg to differ, my lord, but we hear that position because the same approach is taken by Lord Sumption, of course, in the Supreme Court as well.
A different approach by Lord Wilson.
On a doubt expressed, but not a finding. It says, still less does it mean that he is engaging in an activity outside his official functions. We can ignore that sentence for now. And then he says this, as a matter of ordinary language, the question whether an employer is engaged in commercial activity when employing an individual depends on what the individual is employed to do, and not the rate of remuneration which he or she is paid for doing it, or the background circumstances which led to the contract of employment in the first place. I should add that if the position were otherwise, there would be considerable uncertainty as to the scope of the exception.
But here we're concerned not merely with a disparity between the remuneration paid and the market rate or the statutory minimum wage, but with a whole raft of aspects of what this employee was employed to do, for how many hours and in what circumstances of liberty to leave the house and so on and so forth. I mean, it's hard to say that this case is just about remuneration, nor that the alleged categorization of the way in which this person was treated as part of trafficking is simply a remuneration-based proposition.
That is correct, my lord. It's more than just underpaying the claimant in this case, which is the exploitation complained of.
Yes.
But that you will need to grapple with the concept as to, is the commercial activity here, which engages trafficking definition, the end exploitation, or is the trafficking the commercial activity, the business for profit, which happens at an earlier pre-exploitation stage? As I say, trafficking doesn't necessarily involve exploitation. It involves the intention to exploit. So that you don't even have to have actual exploitation. Trafficking can be established in three component parts of trafficking: the act of movement, the means by which the movement is affected, and the act and the means of the movement are affected with the intention to exploit in the future. Now, that would get you to home on trafficking. But we don't see that in the pleaded case. What we see in the pleaded case is complaints about the ultimate mistreatment in employment, of being abused, of being locked up, of being underpaid, for example. So there are, I need to come to that in a moment. But
you'll come to the Palermo Protocol in due course, no doubt.
I really need to deal with that, and that's why I'm
go out of your course.
Please, thank you, Mike. So that's Lord Dyson, and then what we need to do is look at Lord Sumption on this point of ordinary. I'm at this stage of ordinary meaning, because whilst we do this crucible of treaty interpretation, this is the natural first point, at least for a common lawyer. Yeah. So looking at ordinary meaning, and when Lord Sumption looked at it, we go to Lord Sumption at paragraph 21.1. This is at page 876. An activity is not the same as an act. 31.1c is concerned with the carrying on of a professional or commercial activity having some continuity and duration, i.e. course of business. We deal with this in our written case at paragraph 33. The second point he makes on this is at paragraph 21.2, where he says, but it is not only a question of continuity or duration, it is also a question of status. In the ordinary meaning of the words, the exercise of a professional commercial activity means practicing the profession or carrying on the business. The diplomatic agent must be a person practicing the profession or carrying on or participating in carrying on the business. He must, so to speak, set up shop. The position is even clearer in the equally authentic French text, where the word exercer means to practice, to follow, pursue, carry on profession business. So he makes an emphatic, clear, and in my submission, compelling interpretation of the ordinary meaning of the word commercial activity. This is before we even go to the Travaux, etc. So you have, we say, in our jurisdiction, Lord Dyson, supported by the entire Court of Appeal, and Lord Sumption, supported by Lord Neuberger on this point of ordinary meaning. Can I now move on to in context? Which is this, as my friend indicated, is the other aspect one needs to look at under the VCLT. The VCDR, read as a whole, supports the interpretation of 31.1c contended for by the respondent. There are 3 points I want to make on this. The first, the Court of Appeal in Rees concluded that Article 34D of the VCDR, point I took your lordship's ladyship to yesterday, is illustrative of the principle underlying diplomatic immunity. If a diplomat does what he is sent to do, then the activities which are incidental to his life as a diplomatic agent are covered by the immunity. However, when he embarks on private activity for profit, and we say that's an activity that would fall within the prohibition set out in Article 42, he becomes subject to the jurisdiction of the receiving state in relation to that business activity. We deal with this in our written case at paragraphs 43 to 44. The second point. The employment of a private servant to provide personal services was expressly contemplated by the state parties during the negotiation of its provisions and considered to be an ordinary incident of a diplomatic agent's life in the receiving state that would not fall under the exception to immunity. Now, OK, courts might differ as to whether it falls within an official function or in between an official function and a commercial activity. But the fact of the matter is, it is the employment by diplomatic agents of private servants is woven in to the very fabric of the Convention. See Articles 1H, 10.1c, 37.4, 33.2 and 38.2. And we deal with that at our written case, 41 to 42. Thirdly, the proper meaning to be afforded to the phrase outside his official functions is that it covers activities which are incompatible with and not incidental to the role of a diplomatic agent. They do not therefore encompass the employment of a domestic worker because of two things. Firstly, the VCDR expressly contemplated the employment, as I say, of domestic staff by diplomatic agents. And whilst it's not an act in the exercise of functions within the meaning of 39.2, as they find in the Supreme Court ratio in Rees, such employment therefore cannot have been intended to fall within a narrow class of activities that were incompatible with the diplomatic agent's role. It is a personal or non-official act which is incidental to the exercise of diplomatic official functions, but that doesn't mean it falls into the commercial activity category.
Well, I can see that an employment of a personal servant is, but is an enslavement of a personal servant.
There is a fundamental
does that fall
point
within the same incidental category?
It is difficult to conceive that the intention here would be that inquiries by domestic courts into the circumstances of employment or treatment during employment would be entertained in circumstances where the very employment is not something which is within, which is necessarily incidental. So in other words, if it's accepted that employment is incidental to the official functions and may well be a personal or non-official act, looking into the details of the way in which an employee is treated, it is not entirely clear that that might be something that would be condoned by the contracting parties here. It would impact and impede upon the ability of the diplomat to discharge his functions.
But any investigation by a court of whether particular conduct complained of is on one side or the other side of an exemption from immunity may require the court to conduct an examination of the facts, may it not?
Yes.
And while I appreciate that in general terms any court proceedings affecting a diplomatic agent may get in the way of the performance of his duties, it's inherent, isn't it, in a qualified immunity that there may have to be such an investigation to see whether the qualification to the immunity applies.
To that limited extent.
Yes, but if the distinction is between employment and enslavement, well, why is that not sort of factual distinction, one which the courts would have to investigate?
In Reyes, in the Court of Appeal and the Supreme Court, and I shall try to dig up those references, you will see in various parts of their lordships' judgments, they refer to the employment and treatment of a domestic worker in the official residence is not a commercial activity. So you do see the words "and treatment," and therefore that encompasses, you could read, to use your lordship's current wording, the employment and enslavement.
I mean in the modern sense, of course.
In the modern sense, yes. But treatment is covered, we say, enslavement is covered within the treatment. And that is dealt with by their lordships already, we say. It mustn't be forgotten that in Rees, she had a conclusive grounds decision by the Home Office that she was a victim of slavery and that the international definition under Palermo was met. It's not the case here, I say, for reasons I'll come on to in a moment, but in that case they were not, their lordships had in mind when they were talking about the employment and treatment of Miss Rees not being a commercial activity, they were mindful of the fact that she's a trafficked person. And if my learned friend is right, and you can't distinguish the end user from the trafficker, the principal trafficker, then and Mr. Al-Malki was part of the trafficking ring, then they had it at the forefront of their mind that enslavement was not within.
At the moment, I see this as being really the crux of the case, that employment of a domestic help in the receiving state is an ordinary incident of living there, but having a slave in the receiving state is not an ordinary incident of living there.
Well, and then that then brings us on to the trafficking point, which after I've dealt with the construction under the principles in the BCLT, I want to come on to quite swiftly.
I think my Lord has that in mind as an observation, regardless whether you call it trafficking. In other words, it's not a proposition purely based on, for example, the Palermo Protocol.
Well,
it's a proposition based on the level of mistreatment involved, takes it outside an ordinary incident of diplomatic service. I hope I've understood him correctly.
That is interesting, because if the egregiousness of the treatment, if the level of seriousness of the harm or mistreatment, how bad it was, how really bad it was, is part of this categorization that one has to apply, that presents all kinds of difficulties with the immunities application. It means almost in every case, where is the line to be drawn? How much of an underpayment is slavery? How much abuse verbally is it to be? So there's a real difficulty there, which I'm not sure we're assisted. And there is dicta, the EAT in Rees, where Mr. Justice Langstaff, President of the EAT, says egregiousness is irrelevant to this. You're either in the category or you're not. It would be inappropriate to have to enter into the type of investigation and qualitative exercise. One regional or parochial domestic tribunal's view of bad treatment may not be so bad in another contracting member states. One may outlaw forms of harassment, the other may not, for example, and matters of that kind. It's paragraph 44 of Mr. Justice Langstaff's decision, at page 735. Perhaps worth going to at this stage, just so that I deal with the point. 735. Paragraph 44. He says, since this led directly to her conclusion, because the judge in that case was affected in her conclusion that it was a particularly bad case of treatment in that case, he says, since this led directly to her conclusions on the claim for immunity in the following paragraph, it was a material error. The fact that a claim can be labelled as a serious one of its kind, or alternatively a minor one of its type, has nothing to say on the issue whether claims of that type fall within or without the scope of the bar. The actual rather than claimed seriousness of the case would in any event be apparent only at the conclusion of that case, and I cannot suppose it to be the case that the more serious and untried and untested allegation may be, the more likely it is that a diplomat will be required to, in law, to answer it and have to lay aside a procedural bar he would otherwise have relied upon. And that's my position, my Lord, on that. And then at paragraph 41, earlier in the judgment, paragraph 41, page 734, Mr. Justice Langstaff says, next, the seriousness of an individual claim cannot affect the generality of the principle whether, as a class, such claims fall within the scope of an exception from immunity or outside it. I am in no doubt that the judge erred in law. As part of his argument, the judge was wrong to hold the first respondent as acting outside his official functions. Mr. Sethi argued that she was in error in paragraph 34 of her decision, where she expressed her conclusion as being, I therefore believe the employment of the claimant and the way they were treated during the employment was outside the first respondent's job functions.
I don't perceive the appellant to be seeking to establish that the way a person is treated, an employee is treated, is necessary for us to decide that issue for the purpose of this appeal. They rely upon modern slavery. And so the categorization is employment is an ordinary instant of a diplomat. Modern slavery most certainly is not. And that's the categorization that I think that they are trying to establish, if I understand it correctly.
We need to be very careful here on the appellant's case. The appellant's case is squarely rooted on trafficking. They say the assumed facts.
Sorry, trafficking.
It is not that the appellant's case. I'm going to just try and hit this one on the head. The appellant's case is not that the claimant has pleaded that she is the victim of modern slavery in all its forms under the Palermo Protocol. What the claimant has pleaded is that she is the victim of trafficking, and the basis upon which it's argued now is that is trafficking under the Palermo Protocol. Trafficking under the Palermo Protocol, even if that is right, if that is the pleaded case, is not a case of Mr. Basfar is running a business of slavery, is running a business of servitude, is running a business of forced labour. Their case is he's running a business of trafficking. Let's be clear about this. Their case is a Section 2.1 Modern Slavery Act proposition, not a Section 1 Modern Slavery Act crime. This is a case about the crime of trafficking, not the crime of slavery, servitude, forced or compulsory labour. The fact that elements of the subsequent mistreatment of her in employment might tick a few boxes, perhaps more than one, of the ILO indicators of forced labour, says nothing about whether they tick the boxes of trafficking under the Palermo Protocol. It may be evidence of an earlier intention to exploit later on in employment, but there is no pleaded case on that. I keep foreshadowing this submission, but and if you look at the formulation of the appeal in the Statement of Facts and Issues, at page 313, paragraph 23, the appellant's formulated appeal depends on the Palermo definition of trafficking, not any other convention's definition of slavery or servitude or forced or compulsory labour. We need to be very clear, my Lord Stevens, on this point. When one says, isn't this a case about modern slavery? Well, it's a case about one type of modern slavery, not a case about all types of modern slavery. Let me move on to object and purpose. Here I am responding to the appellant's pleaded case, written case at 65 to 69. And the appellant is wrong in that part of their written case, where she says that the object and purpose of the VCDR supports her argument regarding the correct interpretation of 31(1)(c) for the following reasons. The fourth recital does not justify looking at each application of the rules to see whether on the facts of a particular case, the recognition of the defendant's immunity would or would not impede the efficient performance of the diplomatic functions of the mission, nor can the requirements of functional efficiency be considered simply in the light of conditions in the United Kingdom. That's what Lord Assumption says at paragraph 12.3. And the appellant's submissions at her paragraph 68 to 69 amount to an invitation to the Supreme Court to do just that and to ignore the fact that the ambit of each immunity is defined by reference to criteria stated in the articles which apply generally and to all state parties. There are three matters which I say are ignored in the appellant's analysis of object and purpose, or given insufficient weight. Those are these. The first is the rationale behind diplomatic immunity, in particular that exposure to criminal and civil proceedings is always liable to impede the diplomatic agent's functions. I made those points yesterday by reference to Lord Sumption at paragraph 17, Mr. Justice Langstaff at paragraph 34, Barnett at paragraph 55, and it's referred to in our written case at 20 to 21 and 45.3. The second point that is effectively not appreciated is the importance of the reciprocal nature of the diplomatic community. And you've been taken to Lord Sumption at 12.4, Barnett at 51, the US response on page 5262. And we deal with this in our written case at 14 to 15, 17 to 20, 34, and 94. Thirdly, and lastly, the fact that governments, including the United Kingdom, have taken a policy decision that, quote, the apparent iniquity to a private individual is outweighed by the great injury to the public that would arise from permitting suit against the entity or agent calling for application of immunity. Those words are taken from the Tabian case. And yes, trafficking is an abhorrent crime, and there is a great public interest in protecting and punishing. But there is also a great, and when you're putting it in the balance, a greater public interest, competing public interest, if you like, in the protection of diplomats and their functions. My Lord, what I propose now to do is to move on to considering that when one looks at the preparatory work, which is in a sense, because I've looked at the ordinary meaning, I've looked at in context, and I've looked at the object and purpose, we are permitted to go to the travaux préparatoire. There is a plethora of references in there, all strongly supportive of the respondent's position. I don't propose to take you to...
Just before you do, Mr. Ethick, can I just nail you down on what you say the purpose of this exemption from immunity is? I think we can all see what you're saying about the purpose of the immunity, but this is a qualified immunity and there's an express exemption from it. You showed us yesterday two expressions of a possible purpose, one from Lord Sumption and the other, I think, from Lord Dyson. They're quite different. Which one, if either, or maybe both, do you want to nail as colours to your mast?
I'm happy to say that it's both, but there is no... yes, I say both are
right
in play here, engaged.
Thank you.
Can I move on just to confirmatory matters in the travaux? And I want to deal this relatively quickly. We obviously have set it out in the respondent's written case in detail. The point I want to make at the outset, my learned friend only points to one reference in the travaux. We point to a plethora. And what we're doing here in this process is we've undertaken an understanding or analysis of what the ordinary meaning is. We've looked at it in the context and we've tried to understand the true purpose and object behind the provision. And we come to a provisional conclusion. And we can then look to the travaux to see whether that provisional conclusion is justified and confirmed. And I say, when you look at the detailed entries in the travaux that we cite, and then even when you stand back, and we just look at the weight of them, and the direction of them, and the focus of them, it is clear what the object and purpose is, and it's confirmatory of the construction that we pose. There are a great many supportive examples. I'm not going to shy away, other than for reasons of time, my Lord, to not take them, but they're all cited. So what I want to do in relation to the travaux is deal with some of those questions that were raised yesterday, and to show how the travaux deals with those points in particular. And the appellant would say is manifestly wrong to suggest that because the preparatory work doesn't address the exact question at issue in this case, the Supreme Court can't obtain any support from it. They say that at paragraph 80. The preparatory work, we say, is of assistance in determining the intentions of the contracting parties, the scope of 31(1)(c), and the relationship with Article 42 in particular. It's helpful on, and we deal with that at paragraph 66(2) of our submissions. In fact, virtually all cases where there is an issue of treaty interpretation, says Gardner, it is the practice of courts to look at the preparatory work, and that's page 4316. The preparatory work to the VCDR, including the careful commentary produced by the Commission on its draft articles and the published records of its debates, will be of particular assistance, says Denzer, at page 1408. Lord Wilberforce's analysis about the circumstances in which reliance can be placed on the preparatory work when one looks at the case is obiter. If one looks at 2051 at B to C, I'll simply make that submission. The preparatory work confirms the interpretation reached by Article 31 that the respondent has reached. We say that for 4 reasons. The first is that the commercial activity must be exercised by the diplomat. They must engage in the course of business or an alternative occupation in the receiving state. They must set up shop. If one observes paragraph 27 to 28 at 4181, in the preparatory work, if I could ask your lordships and ladyship to look at page 4181, for example, paragraphs 27 and 28. 27, Sir Gerald Fitzmaurice, rapporteur, doubted the advisability of Mr. Zurich's suggestion. Paragraph 1C of the article applied to cases where a diplomatic agent conducted a regular course of business on the side. Such isolated transactions as, for instance, buying or selling a picture were precisely typical of the transactions not subject to the civil jurisdiction of the receiving state. Annoying as it might be for the other parties to such transactions in the event of a dispute, it was essential not to accept such transactions from the general rule, for once any breach was made in the principle, the door would be open to a gradual whittling away of the diplomatic agents' immunities from jurisdiction. And the chairman pointed out that the article referred to commercial activity. A single transaction would hardly constitute commercial activity. Of course, even a single plunge in the waters of trade might suffice, but it must be in the waters of trade. And then if one goes to paragraph 33, in the column to the right, Sir Gerald Fitzmaurice, rapporteur, agreed, though pointing out that Mr. Skelly had in effect said exactly the opposite of Mr. Zurich. According to the latter, an isolated transaction could, by a very little stretch of the imagination, be presented as constituting commercial activity. But whilst it might be feasible, clearly the point there is that it's a course of business, a regular course of business on the side. And my lord, that is supported by Sumption paragraph 21.1 and Lord Sumption at paragraph 36 in the Supreme Court. I would, at this stage, you have all the references to the travaux préparatoires. I want to deal with the points that have been given rise to questions, and therefore the focus of this appeal. The appellant's entire case on the preparatory work does depend on some isolated statements in the preparatory work, but they don't support her case. The statements by Mr. Bartos, delegate for Yugoslavia, it's important, we say, to look at the statement in detail. And in this respect, I would ask you to go to the travaux in some detail at this stage. He stated at page 4165, if I could ask you to look at that, he stated at page 4165 at paragraphs 31 to 32, he had been asked by Yugoslav trade unions to raise a special point in connection with immunity from jurisdiction. There were numerous examples from case law to support the claim that diplomatic agents in entering into either a tacit or formal contract with domestic servants thereby accepted the jurisdiction of courts competent to deal with labour questions. While it would be premature to talk of a definite rule that entry into a labour contract implied acceptance of the jurisdiction of labour courts, there certainly was a marked trend in case law in that direction. First, we say Mr. Bartos explicitly accepted that any trend was not sufficiently developed to amount to a rule. And secondly, we say the point is not that there was a developing practice in favour of recognising an exception to diplomatic immunity for employment contracts, as alleged by the appellant. The alleged trend here related to the interpretation of the waiver of immunity. Thirdly, we say the delegates were clearly not in favour of such an interpretation. Article 32.2 provides that the waiver of the state immunity must be express. The other point we say here is that Mr. Bartos' suggestion that the delegates might encourage that trend was rejected by Mr. Sandstrom, the special rapporteur, at page 4165. at paragraph 33. He agreed that diplomatic immunity from jurisdiction was often a source of inconvenience. He was not sure, however, that the inconvenience in the case cited by Mr. Bartos was so great as to warrant making an exception to the rule. Sympathetic as he was to the misfortunes of the small man, he did not think it desirable to make too many exceptions. Mr. Bartos's suggestion was not discussed further. At page 4218, paragraph 42, Mr. Bartos stated he would have been inclined to admit other exceptions as well, particularly in the case of actions arising out of an employment agreement relating to a locally employed servant of a foreign diplomatic mission. As legal advisor to the Yugoslav Ministry of Foreign Affairs, he was placed in a difficult position when he had to explain to such a servant that his only means of redress was to retain the services of a lawyer in the foreign sending state concerned. The import of this statement, we say, is clear. There was no exception to diplomatic immunity for employment claims by domestic servants against diplomats.
Paragraph in 4128, is it?
42. I've dealt with the waters of trade point. On that, the appellant relies on the chairman's statement that even a single plunge in the waters of trade might suffice as a commercial activity. And our point there is simply that the chairman's statement must be read in full. He pointed out that the article referred to commercial activity. A single transaction would hardly constitute commercial activity. Of course, even a single plunge in the waters of trade might suffice, but it must be in the waters of trade. And first, we make the point that the chairman was clear that the single transaction would not amount to a commercial activity. And secondly, the chairman only stated that a single plunge might suffice. And thirdly, the plunge must be into the waters of trade. So it must be a trade. Must be a business activity.
Presumably you would accept that if the diplomat entered into a commercial activity, started running a business or a farm, and engaged slave labour within that commercial activity, and there was then a claim by one of those employees, that the immunity would not apply.
He would, my lady, on those facts, possibly be guilty of enslaving, subjecting to servitude, and forcing compulsory labour, and the crime of Section 1.1 offence.
No, but I mean, if somebody who was engaged by the diplomat in that business then brought a similar claim as Miss Wong is bringing here, there would be no immunity to bar that. The difficulty that we have here is that the enterprise in which she is providing her services is not of itself a commercial activity.
Indeed.
And therefore the question is, can her employment of itself be a commercial activity when the tasks that she's performing are not ancillary to a different commercial activity? But that seems to be what they're discussing when they're discussing this point about the duration of it, or a single act.
Yes, there must be a.
If a diplomat buys 20 bars of chocolate because he's set up a sweet shop, then buying those bars of chocolate is part of the commercial activity.
Indeed.
If he buys them because one of his children's having a party, it's not part of a commercial activity. No. But then the question is the buying of them itself a commercial activity? To which you say,
if you're buying
no,
it to sell it on for a profit, if you're going to sell it to your guests and charge them at the party, you may.
No, I'm not talking about a party where you charge the children for attending. I'm talking about an ordinary party.
You may extract a benefit from the children in terms of domestic chores and things of that kind in return for the reward. That may be the benefit that you acquire, the profit from that you acquire, but that doesn't make it, again, a commercial activity, for example. There is a real critical distinction here between the case is really one based on a benefit that accrues to the employer here through underpayment. The other forms of treatment aren't really beneficial treatments in the sense that they're just bad treatments, but the financial profit element. I think the reason, my Lord Briggs, is in relation to the focus on the underpayment is that's where the personal profit element becomes quite more literally engaged here, rather than the other elements of mistreatment. Let me
Can I just raise one thing we've
Yes.
been saying? Most of the examples which we've been discussing, the comparative examples, are about engagement as a principal in a trade, as the, if you like, the proprietor of the trade, the person responsible for the trade. Does the exclusion also remove immunity from a diplomat who is simply employed as an employee in someone else's trade? I'm asking that because if one then applies your answer across to the Palermo Protocol concept of trafficking, it may be that in a case where a diplomat merely employs a modern slave who's been recruited and transported by somebody else,
Yes.
they're only taking a part in one stage of a process which is viewed as trafficking overall. And that's why I'm just groping towards an understanding of whether the immunity requires you to be a principal or just a participant of some kind in the trade.
It requires your activity, your conduct, your behaviour, your actions to be or personal to be part of a course of business for personal profit.
Well, what about someone who is? What about going in as a senior employee in somebody else's business or a company's business?
Well, if he's part of, on the facts of this case, because trafficking is alleged, if he becomes an employee of the trafficking ring...
No, forget trafficking. I'm just asking you in purely general terms at the moment as a sort of first step into a process of analysis. Let's suppose somebody becomes an employee, but not in any sense a principal or owner of a trading business, for someone being a diplomat. Does he lose his immunity in the context of any liability incurred while he is so employed?
If he is engaging himself in a commercial undertaking for which generates a revenue stream for him, then which he is, then and that is firstly that the activity he is engaging in is commercial, and secondly he is receiving a personal direct remuneration from it, then conceivably.
So a profitable participation in someone else's trade as an employee of that someone else would fall within the exception to the immunity?
At the moment, I can't think of a clear submission to say why emphatically it should not.
No, okay.
But one of Professor Denner's examples is paid employment outside the mission.
Yes. Well, of course, if you're moonlighting as a serving diplomat, that's not seen to be what you should be doing in the receiving state. If you're moonlighting in a commercial enterprise, when really you should be undertaking your official functions. I mean, that's what this is perhaps aiming at. That is a business activity inconsistent with your diplomatic functions. But employing a domestic servant is to be expected. It may be even expected that occasionally there'll be claims of, or there'll be actions of harassment and bad treatment of domestic servants. So some diplomats may not treat all their domestic servants very well, but that doesn't necessarily mean that. Yeah, I'm being taken to Lord Sumption's analysis on this point that Your Lordship, Lord Briggs, has raised. It's at page 876, 21.2. It's the paragraph I cited a few moments ago, where His Lordship observes the diplomatic agent must be a person practicing the profession, but that's the professional part, or carrying on or participating in carrying on the business.
So participation under Lord Sumption's broad definition is enough?
In the business. So you have to identify the business that he is participating in. It's far too...
In Lord Sumption's example, it's not just the person who sets up shop, it's the shop assistant as well.
Perhaps.
Thank you.
But this does bear on, and I really do want to deal with the trafficking point. I just want to make one point on Article 42, and the link with 31(1)(c), and I want to deal with how the travaux support the construction that the respondent contends.
I'm conscious that we've created a 3-hour continuous stretch this morning. Do let us know if at any rate you would like the court to take a short break, and if you would, when? Because
My Lord, I'm very grateful. My
flow.
primary concern here is the limitation that's been placed on my dealing with Mr. Otty's case. And I'm far more concerned with having to. I'm stretched already.
Well, if you can cope, we can, Mr. Sethi.
Thank you. I can certainly cope. I may invite this court's indulgence on going beyond 11 o'clock on this primary point.
I think you mean 12 o'clock.
Sorry, 12 o'clock.
Carry on.
How does the travaux preparatoires confirm the respondent's construction that it invites this court to accept, that Article 42 does indeed dovetail with Article 31(1)(c), that the requirement of personal profit is there, expressly or by necessary implication, in the concept of the exception? The origin of Article 42 was an amendment proposed by Columbia, page 4225, paragraph 3. It was inserted at a very late stage. I understand by that stage, 31(1)(c) had already been voted on. That's observed at Lord Sumption, paragraph 37. The concern was that the commercial activity exception to diplomatic immunity might appear to condone commercial activities of a diplomat serving diplomat. That's page 4215 at paragraph 14. Mr. Linares, who was the delegate for Guatemala, he said paragraph 1(c), as it stood, might be interpreted as an implicit authorization for the diplomatic agent to engage in a professional or commercial activity when such activities were not compatible with the exercise of diplomatic functions. And so, for example, at page 4226, per the Venezuelan delegate at paragraph 7, quote, the exercise of gainful outside activities by a diplomatic officer would be detrimental to the dignity of the office, was the concern. At page 4226, per the Spanish delegate at paragraph 10, he said, it applied with particular force to commercial activities. A diplomatic agent who engages in such activities would be guilty of an act of unfair competition. His commercial activity would be detrimental to his own nationals and to other persons engaged in the same trade. The Ceylon delegate at page 4226, paragraph 17, said this. He thought that the supporters of the proposed new article had in mind a regular professional activity from which a permanent income was derived, and not an occasional activity, particularly of a cultural character. There could be no objection to a diplomat who happened to be a scholar of repute and an authority on a special subject giving a course of lectures at a university in the receiving state. He suggested that the drafting committee might consider whether the proposed provision should be applicable solely to activities for which remuneration was paid. So it's remuneration, not a benefit. However, there arose during the course of the discussion a concern that Article 42 might prohibit a diplomatic agent from engaging in literary, artistic and cultural activities in the receiving state. And the source of this concern is page 4226, at paragraph 11, per the Spanish delegate, who said that the proposed provision was not meant to debar diplomats from the exercise of literary or artistic activities. We ask you to also see 4226, the Colombian delegate at paragraph 22, where he said the question had also been raised of literary and other cultural activities. The proposed provision was not intended to debar diplomats from such activities. As a result, the Malayan delegate proposed at page 4227, paragraph 33, that it should be limited to commercial activity for personal profit. So this is how, when one looks at the history of the negotiating position of the parties, the way in which the words for personal profit came to be inserted, in how Article 42 first came to be conceived, and how it came to be conceived in the context of Article 31(1)(c), and how the words for personal profit were desirable to be inserted into Article 42. The explanation is found in the Travaux Preparatoires, and that explanation is confirmatory of the respondent's construction, applying ordinary meaning, applying objective and purpose and context to 31(1)(c). And I do make the point again that the great many more references that we cite in the travaux are all supportive of the respondent's interpretation. My Lord, I'm just going to check, given that I see I have 34 minutes or so. Could I also ask your Lordship's Ladyship to read page 4193, paragraph 7. And it goes to the scope of the rationale for the intervention, for the exception to immunity. The third exception arises in the case of proceedings relating to a professional or commercial activity exercised by the diplomatic agent outside his official functions. It was urged that activities of these kinds are normally wholly inconsistent with the position of a diplomatic agent, and that one possible consequence of his engaging in them might be that he would be declared persona non grata. Nevertheless, such cases may occur and should be provided for, and if they do occur, the persons with whom the diplomatic agent has had commercial or professional relations cannot be deprived of their ordinary remedies.
What's this from, sir? What is this extract from? I know.
This is from the ILC draft articles on diplomatic intercourse and immunities with commentaries, which starts at where the front cover sheet is at 4183. Now, that deals with the points on the travaux that touch upon the questions that were raised yesterday that do go to some of the central issues. Can I just say in view of the time, that we then move on to look, having done the exercise of construction, in accordance with the VCLT, and just one other point, last point on that to highlight is yesterday, under the VCLT 13, the key provision of the VCLT that my learned friend relies upon is 31.3c, any relevant rules of international law applicable in relations between the parties. And he was put to task on the fact that a development in an international relation just between two parties, or some of the parties, but not all the parties to the convention, would surely not be relevant here and engaged by this aspect of the interpretative rule. And we say it is very clear. It's talking about rules of international law that apply between the parties to this convention, the parties being all the signatory states.
Not all of them.
The parties. It certainly can't be just two of them, or regionally.
And once the treaty gets accepted by enough parties, then it's liable to be part of customary international law, isn't it?
Yes. There was a section I was to address you on in terms of the respondent's interpretation being supported, as it clearly is, my learned friend accepts it, so I don't need to go to it now in detail orally, by domestic jurisprudence insofar as there is in Prop End, by all the available reliable international jurisprudence on point, on 31.1c, see particularly the American jurisprudence, where every single American decision on point on the scope of the diplomatic agent's immunity and the exception supports the respondent's position and supports that it has to be for personal profit. And the recent US response as well to the petition continues to support that, despite the Portuguese outlier. And we see that Lord Sumption and Lord Dyson in recent cited Tebian and the US authorities with strong approval. And you'll recall at the end of even Lord Wilson's speech that he says it would be, even he says, a strong thing to depart from Tabulum. Paragraph 68, he identifies the perceived problems. He says it's that an international treaty calls for international interpretation by reference to broad principles of general acceptation. And that's perhaps the more reliable phrase, my Lord Legate, I should pray in aid of, general acceptation, stagline. And never more obviously than when every state dispatches its diplomats abroad in expectation of their protection under it. So it would be a strong thing for this court, the Supreme Court, to diverge from the US jurisprudence set out in Tabian and Mufti, cited in paragraph 23 above, and to adopt the robust interpretation of Article 31(1) for which Ms. Race contends. And so the conclusion there is that all that can be done, given the current state of the law, as even Lord Wilson sees it, as supported by Baroness Hale and Lord Clark, is that it is far preferable, to use his language, for the ILC, midwife to the Convention, through the Article 17 mechanism, which created it, to consider, to consult, to report on the international acceptability of an amendment to Article 31, which would put the matter beyond doubt. And that's a recognition of international general acceptation can only reliably be obtained through that accepted, agreed route to any development of or any interpretation of 31(1)(c), which is against the grain of all the international jurisprudence to date. I understood from yesterday that my learned friend is not pursuing, not seeking to modify or amend the meaning of the convention, simply saying that the intention was that trafficking would be would be a business activity. But the difficulty he has is the observation of Lord Wilson at paragraph 67 of Rees, where Lord Wilson stated that the parties, he's adamant that the parties would have rejected any suggestion that the proceedings brought by Miss Rees related to any commercial activity exercised by Mr. Al-Malki. And that's the point I made earlier, that all of the Supreme Court is very clear on that. So even they rejected any such argument. I don't therefore need to deal with in detail the navigational rights issues and those matters. What I want to really get to now, quickly, is the limits of the assumed pleaded facts. So we're applying the process to this case. By consent, I didn't force it upon Miss Wong's counsel and solicitors. By consent, the tribunal determined the preliminary issue of immunity on the facts as set out in the claim form. You're not assisted by any suggestions of phrases like taking the claim at its highest and things of that kind, because that's superfluous. It was limited to the four corners of the pleaded case. The tribunal proceeded to confirm those assumed pleaded facts, essentially parrot them at paragraph 6 to 14 of its reasons at page 462. It was careful not to go a word beyond the pleaded case. The EAT determined the appeal on the same basis. Of course, the EAT couldn't go beyond that which the ET decided below, at page 431. The parties agreed a statement of facts and issues which, for this appeal, which assiduously track the assumed pleaded facts, page 302. The Supreme Court now should, of course, determine the issue on the assumed pleaded facts only. We know the difficulties of straying beyond that and artificially inferring other unpleaded facts, and the difficulties of that when a case is run on a schedule of agreed facts. See Mr. Justice Neuberger in the Morris case, at paragraph 410 to 411, and the McLaughlin case. Sorry, the Morris reference is page 3155, to 3156, and the McLaughlin reference is paragraphs, is page 2524 to 2525. It's referred to in our written case at paragraph 69. This is the importance of sticking to the pleaded case. Now, there are numerous references in the appellant's pleaded case which impermissibly seek to introduce unpleaded facts into this appeal. And the Supreme Court, we know and trust, will be alive to the dangers inherent in the claimant seeking to introduce new facts at this late stage in such a casual and unstructured manner. And that's to borrow from the words of Mr. Justice David Steele in the McLaughlin case at page 2524, para 63. This, after all, is a second appeal, which would be, and widening the goalposts at this stage is to the obvious and severe prejudice of the respondent, Mr. Basfar. Now, contrary to the appellant's written case at 25 to 26, it's impermissible to even seek to introduce new facts not pleaded and not forming part of the case when some references are made to matters which were not even adduced in evidence before the tribunal. This is the respondent's written case at 71 to 72. So, the assumed facts, we say, do not meet the international definition of trafficking. Why? The claimant's pleaded case is squarely put on the basis that she is a victim of trafficking, page 488. There is no assumed pleaded fact that she is the victim of any other form of modern slavery in the form of slavery, servitude, and forced or compulsory labour. She doesn't use those words. She uses just trafficking. Says she's the victim of trafficking. She relies on the Article 3A Palermo Protocol definition of trafficking. My lords, my lady, there is no assumed fact that the claimant has been recognised by the Home Office in this case as an actual victim of trafficking.
But are you accepting that we're to assume that she's a victim of trafficking, or not?
We accept that she pleaded in her case, I am a victim of trafficking.
But are you making a submission that the facts, if proved, are not sufficient to disclose human trafficking?
Yes.
Or did you make that submission to the Employment Tribunal?
Yes. And can I say why? Can I take you to the references?
Yeah.
So, the point I was just making at the moment, she merely asserts, I'm the victim of trafficking. Nothing else in that pleaded assumed facts ticks the three components of trafficking. And I'll come on to those. And the other broad proposition I make is that she doesn't plead that the Home Office has decided she's the actual victim of trafficking, unlike, my lords, in the Rees case. In Miss Rees's case, she had a conclusive grounds decision by the Home Office. Lord Dyson referred to that in two sections of the Court of Appeal decision, paragraph 1 and paragraph 30. Is it? In this case, she only pleads that the Home Office has found that she's a potential victim. There is a crucial distinction. When the claimant pleaded the bare assertion in ET1 box 15, it's page 488, my lord. 31. So in the Rees case, paragraph 1 and 31, Lord Dyson found that the Home Office had reached a conclusive grounds decision, that she is, in fact, victim of trafficking. That's not this case. When the claimant pleaded this bare assertion, I am the victim of trafficking, it is not obvious from that bare assertion, as my learned friend suggests, that she is referring to the international definition of trafficking in doing so. When, in the second paragraph, my lord and my ladies, in box 15 at page 488, she says she has been recognised by the Home Office as a potential victim of trafficking on the basis of her experience with the respondent. What does that mean? Well, we know that the Home Office does indeed apply the international Palermo Protocol definition of trafficking, and one would have thought that if she's referring to a Home Office decision, we can impute that they are applying the Palermo Protocol definition in coming to their decision making. But their decision is that she's only a potential victim. It's not a fact that she is a victim according to them.
In the Modern Slavery Act, with human trafficking crime, do you accept that definition of human trafficking is the same as the Palermo Protocol one, or goes further, or not as far? Or?
The same.
It's the same.
There's one aspect in which it might go further. in terms of the actions. I think it refers to transferring. I can take you directly to it. The Modern Slavery Act is in. Okay. Is it in the second bundle? But for all intents and purposes, for current purposes, my lady, I accept that the government fulfilled its obligation to domestically implement the Palermo Protocol and the Anti-Trafficking Convention by way of introducing criminal offences fully compliant with the Palermo Protocol definition.
Because that definition in the Act does seem to encompass somebody bringing into the UK for their own purposes someone who they then intend to exploit rather than them trading in the people.
Yes, it's at the MSA is at 151519. And the human trafficking offence at 1521. And I was going to take your ladyship and your lordships to this.
2 subsection 4A is a person arranges or facilitates the victim with a view to the victim being exploited if the person intends to exploit thee.
Yes.
During or after the travel.
Yes.
Or knows or ought to know that another person is likely. So it does cover bringing somebody in whom you intend to exploit yourself.
Yes, yes. Now, my lady, the point I was making at the moment before I come to the, and this deals with the components of trafficking too, but I just want to deal with this position that I say this is a case where the assumed pleaded fact is simply that the Home Office has made a provisional preliminary suspected victim of trafficking decision, has not made a conclusive grounds decision. So there isn't a finding of fact that can be made that the Home Office has applied the Palermo Protocol and has made a decision that Mrs. Wong is the victim of trafficking.
There's to the application form 488. Where do we find the particulars that are attached to that application?
That is on the next page, I believe, in the bundle.
Yeah.
And I want to look at that as well. Now, the point I'm making at the moment is there's an important and critical distinction in this appeal between an assumed fact that the Home Office has made a reasonable grounds decision that it suspects but cannot prove that the claimant may be a victim of trafficking, as compared to a substantive conclusive grounds decision, as in Rees, that it believes on the balance of probabilities that the claimant is in fact a victim of trafficking. And the assumed fact that the Home Office has made only a reasonable grounds...
Did you ask, then, the Employment Tribunal to hold a fact-finding hearing? Because it appears to me that you're contesting that she is a victim of trafficking. And did you ask the tribunal to actually have a fact-finding hearing in relation to that?
The parties agreed that the way to proceed was on the basis of the pleaded case. So there was the option of proceeding on hearing evidence and proceeding on the basis of the tribunal making findings of fact on that evidence.
Did you seek to exclude the further evidence that the appellant wished to lodge before the tribunal?
There was no... we were not... The parties were content to proceed on the basis of the... I was not suggesting that the tribunal cannot proceed if it heard the evidence and make findings of fact. If the tribunal was to make the if we were to proceed on an assumed agreed schedule of facts, the parties agreed that it was sufficient that those facts upon which the claimant relied were those facts in the pleaded case.
Well,
the
paragraph 15 of the tribunal's decision says the parties agreed that the question for the tribunal was whether the respondent's employment of the claimant as a domestic servant in assumed circumstances of modern slavery was a commercial activity. So unless you're telling me otherwise, the judgment seems clearly to record your agreement to proceed on the basis that this is a trafficking case.
We were proceeding on the basis that the claimant was certainly saying that she had been trafficked, but the best she could say was that the Home Office had only found that she was a potential victim.
Well, but the attitude, I'm not sure what the attitude of the Home Office in one case or another case has got to do with it. Her pleaded case is that her travel to this country was facilitated by your client.
She doesn't plead that.
Well, in order to obtain a visa, she was provided with a contract or statement of main terms and conditions of employment.
Yes, and that
She's plainly pleading assistance in her travel by your client. There was nobody other than your client provided with the contract, presumably. She pleads in paragraphs 3, 4 and 5 a series of facts from which, putting them all together, one would ordinarily conclude that she was being exploited. I'm just thinking of the definition in section 2.4 of the Modern Slavery Act.
Yes, can I do that?
I'd rather look at it against the definition of the Palermo Protocol, because that's the relevant instrument for present purposes.
Okay, well, if we've established that she is not in possession, she's not even pleading that she's in possession of the Home Office decision, which is a conclusive grounds decision that she is a victim of trafficking. So, in other words, the Home Office decision is not either here nor there. Other than, my lord, I say that if you say to a tribunal in a pleading, I'm the victim of trafficking, and you then, that's all you say, and you then refer to a Home Office decision which we know considers the Palermo Protocol definition in coming to its decision making, and that it has not found that you're an actual victim, it's only found that you're a potential victim, because there is a process whereby they need to go on to make a conclusive grounds decision, and they had not done that in this case on the assumed facts. There is a two-part consideration process for the single competent authorities to come to a decision when they're identifying victims of trafficking. It's either you make a suspected case decision, and then often days later, then you come to a conclusive substantive grounds decision that they are on the balance of evidence a victim of trafficking. But that wasn't, the latter is not part of the assumed facts.
To bring you back to Lord Briggs's question, isn't there a compelling inference that the only person who brought it to the United Kingdom is the respondent? What other inference could you possibly have?
The requirement. I see that. I do see the point, but that is not an assumed pleaded fact. That's the point I make.
So your submission is because she hasn't said in terms your client was the person who brought it to the United Kingdom, the alleged facts don't amount to an allegation, if proved, of human trafficking. Is that your contention?
If one is taking a pleading as the assumed facts and then applying the Palermo Protocol definition of trafficking to those facts, one is looking to see whether the very strict definition is met. Otherwise, you're making...
So are you saying that because it doesn't allege in terms that your client was the person who brought her to the United Kingdom, it hasn't alleged facts which disclose human trafficking? Is that your submission?
One of the reasons why I say it doesn't meet the definition.
And were any of these submissions made to the Employment Tribunal and the EAT? And if so, why do they appear nowhere in the recitation of your arguments? Is it just that they were just ignored, or
well, we do, in our written case to the Supreme Court, we do indicate that there is no finding of a conclusive grounds decision. Because we were by consent, the parties agreed to stick to the assumed pleaded facts. That meant that below the claimant had to argue that the assumed pleaded facts met the definition of trafficking, but the tribunal doesn't appear to have.
Did you contest that they did, though? Did you say, on these pleaded facts, that does not amount to trafficking, end of story, even if I'm wrong about all the other arguments I'm making? Because I don't see any trace of that submission. It all looks as though you accepted that she was to be assumed to be a victim of human trafficking.
No, we said we're happy for you to take what she says, what she pleads at face value.
Including the inferences.
No.
Well, why
No.
not?
Because we were perfectly content to rely upon the binding or at least persuasive dicta of Lord Dyson in the Court of Appeal and of Lord Sumption in the Supreme Court on the other grounds in terms of the construction of 31(1)(c). We didn't need to go into great detail on this, but to prove the point that this was something that was in argument, in play, my Lord, Lord Legate, if one goes to paragraph 19, this is after the tribunal...
Sorry, in what?
Paragraph 19 of the tribunal's reasons at page 464. The tribunal effectively copies in the earlier paragraphs 6 to 14 the pleaded assumed facts. And then, under the heading of the parties' arguments, at paragraph 15 onwards, at paragraph 19 at the top of page 464, because we were sticking to the assumed pleaded facts, the claimant had to argue, because it's not clear from the assumed pleaded facts, that they give rise to meeting the definition. It says the claimant contended, that was part of the argument in the case, that the facts of the current case, in other words, the pleaded case, were also slightly different to those in Rees and Malky, because in the current case, the respondent had himself trafficked the claimant, whereas in Rees, it was not clear that the claimant had trafficked the employee, rather than simply employing a person who had been trafficked. And we say on the pleaded case, our argument was on the pleaded case there, Mr. Basfar, on her pleaded case, is simply employing someone who's been trafficked, just like in Rees. But she was seeking to argue that point. But the tribunal didn't need to go there, because we were even more preoccupied with the precedent issues of dealing with, because the case was almost on all fours with Rees, almost, to dealing with Lord Dyson in the Court of Appeal and Lord Sumption in the Supreme Court.
So you're not, are you contesting that she was trafficked, or are you only contesting that she was trafficked by your client?
We are contesting both, and can I say why? There are three components to trafficking, as my lady knows. The trafficking movement action, that must be achieved by certain specified means in Article 3A, and at the time of moving the human being by certain actions which are achieved by those certain means, there has to be at that time a present intention to exploit the human that's being moved. Now, if you meet the movement action by specified means, achieved by specified means, with the specified intention at that time, then you meet the definition of trafficking. And it doesn't matter that there isn't any ultimate exploitation. If the aim of the process was ultimately to underpay her, abuse her, lock her up in a house in London, that might amount to some other form of defined modern slavery, such as domestic servitude, a form of exploitative treatment. But that is not trafficking. And that's why the allegations, the assumed pleaded facts of mistreatment that are pleaded, might go to a servitude case, but they don't establish the Article 3A Palermo definition of trafficking. So let's just delve into a bit more detail on that. To be a victim. So as to the action element, this concerns the movement of human beings. To be a victim of human trafficking, the person needs to be subjected to the act of either recruitment, transportation, transfer, harbouring, or receipt, which includes an element of movement, whether national or cross-border. And when one looks at Section 2.3, my lady, of the Modern Slavery Act, that provides that a person may, in particular, arrange or facilitate visa travel by recruiting, transporting, transferring, harbouring, receiving, or transferring or exchanging control over the victim. And Section 2.5 provides travel as meaning, amongst other things, arriving in or entering any country. So the process of trafficking is the travelling. It's what happens in the course of the travelling.
But it includes the receiving.
It includes the receipt. There's a sequence there which runs from recruitment, transporting or transferring or harbouring in the process of the movement, and then ultimately receiving.
What I can't understand is, why is not the taking of Ms. Wong into your client's household when she arrived in the UK receiving?
If she is... If it is part of Mr. Basfar...
I can see it might not be harbouring, but why isn't it receiving?
Let me deal with that. I think harbouring is inappropriate here, because if the end of the trafficking process here is when he receives her, well, the facts of the case here are that he receives her from himself, because he is her employer in Saudi Arabia. He's her employer here. Yeah. There's continuity of employment. There is. Let me just deal with the. So you have the travel point that the movement is essential. I do not accept for a moment that the trafficking in this case continues post receipt, if receipt meets the definition. In other words, the employment of her in the exploitative circumstances is not trafficking. That's the servitude, or the ultimate mistreatment. That might have been the aim of the movement, but it is not part of the trafficking itself. And if one looks at, my lord, 5121 is the extract from Hansard, which is relevant here.
But why is Hansard relevant to the construction of the Palermo Protocol?
It's to understand where trafficking stops and where the offence of servitude, slavery, forced labour starts.
But shouldn't we be looking at the Palermo Protocol?
It's the same. It's essentially the same point, because the Modern Slavery Act is implementing Palermo.
But Hansard can't possibly be an admissible travaux préparatoire for the Palermo Protocol, can it?
No, but we all accept that the definitions of trafficking and of slavery, servitude, and forced labour in the Modern Slavery Act is implementation of the Article 3A definition in Palermo.
But we're dealing with an international convention, and we found at page 321 the relevant parts of it, and that's the definition that we should be applying.
The tribunal claims don't relate to the trafficking act of receipt, even if you infer that Mr. Basfar received her at Heathrow Airport in London, or wherever it might be, when she arrived from Saudi Arabia. But that's not the basis upon which the claimant pleaded her trafficking claim. Her trafficking claim is pleaded only in relation to aspects of mistreatment.
In addition to the definition,
yes,
in the Palermo Convention, that has been now adopted by the European Court of Human Rights in Rancev in relation to Article 4. But the crucial one is the Palermo Protocol.
The crucial one is the Palermo Protocol, that's right.
Yes. And it means the recruitment, transportation, transfer, harbouring, or receipt of persons. Well, and there's, to my mind, a case so far, unless we're persuaded to the contrary, recruitment, transportation, transfer, and receipt.
Well, my lord, you need to. My learned friend was quite clear. He said all aspects of Palermo forms the basis of his case. All of the. He says there is recruitment pleaded here. He says, in effect, he says there is. Transportation pleaded here, there is transferring, there is harbouring pleaded in accordance with Palermo, there was receipt pleaded. I say that's not pleaded in accordance with Palermo. It doesn't meet the definition. So for example, contrary to what he says in the written case at 23.1, there's no assumed pleaded fact that when the claimant travelled to the UK, when she travelled to the UK, the respondent engaged in an action of recruiting her. I mean, after all, she was already his employee. So the movement of her didn't involve recruiting.
Recruitment occurred in Saudi Arabia, one assumes, because that's where she was employed.
Indeed, so the recruitment, when he recruited her, there's no pleaded suggestion here that the initial recruitment, that he somehow recruited her from Philippines or when he was in Saudi Arabia. No. There's no suggestion of that at all. So recruitment in this case isn't engaged.
If I have an establishment with 30 employees in it in country A, and I want to go and conduct an activity in country B and to take some of them with me, it's not a misuse of language to say I recruit some of my country A employees to come with me and work with me in company B.
Well,
Is it?
When a new contract is proffered.
Yes.
Well, my lord, we say that that is not pleaded here. There's no assumed pleaded fact that he brought her. Yes, she was brought, it says, but my Lord Legate's point, maybe not my best point, but I say that it's not pleaded that he
Well, at the moment,
facilitated.
I can't see that any of these pleading points are points that are open to you. In your grounds of appeal to the Employment Appeal Tribunal, none of them was taken, so far as I can see.
The Employment Appeal Tribunal. Now, my Lord, the Employment Appeal Tribunals, the grounds of appeal to the Employment Appeal Tribunal were based on the errors that we identified of precedent and persuasive authority and the approach of the tribunal to that.
And if you were going to say that the decision was wrong for another reason, then that had to be a ground. I mean, there's no reference to any of these in the Employment Tribunal judgment, but I think you're telling me that you made all these arguments and the judge just made no reference to them.
Indeed, what we're saying is it's in many respects one of the reasons why. Certainly, I was content to rely upon the pleaded case because I was satisfied that it did not meet the international definition of trafficking. To simply say you've been trafficked is not enough, and to just simply refer to ultimate actions of mistreatment is not enough.
Well, I'm looking at time, Mr. Sethi. We've heard your submissions on the pleading points. The pleading is a very short one, and I think the point is a fairly short one as well. So we could probably usefully, bearing in mind the time, move on.
I'll make just this point on this, that even if the respondent on the pleaded case is pleaded to have done the things necessary within the Palermo definition, in the way Palermo sees it, achieved in the manner in which Palermo achieves it, with the intention at the time of the movement as Palermo intends it or defines it. And there is no there's no pleaded case about his intentions, by the way. If you are to meet the Palermo protocol definition, you have to say that I've been, at the moment, the process of trafficking has been done with the intention to exploit me. Now, of course, she pleads ultimate subsequent exploitation, and that might be evidence of anterior intent, but it's not conclusive.
What's the end of that sentence, Mr. Sethi? You said even if the pleaded case does say that your client has trafficked her within the meaning of the Palermo Protocol.
Then I was going to say, then there is no assumed pleaded. Sorry, even if the recruitment element, the action element is met, there's no assumed pleaded fact that at the time of the respondent's movement of the claimant, which amounts to the trafficking movement, he intended to exploit the claimant in the UK. The assumed fact that he did, in fact, exploit her after her arrival, after his receipt of her in the UK, to take my Lord's position on this, tells the court nothing about his intention at the time of transporting her to the UK. And again, it should be noted that she didn't plead that she was being treated badly or exploited when she was employed by him for some time in Saudi Arabia. So it's not that there's an inference that when he was at the point of moving her from Saudi Arabia to the UK, there was an intention to treat her badly and exploit her. There's not even an inference that she was treated, let alone a plea that she was treated badly in Saudi Arabia. For all we know, it was absolutely fine. So where do we see in the assumed pleaded facts that the necessary critical third component for the Article 3A definition, that at the time of movement there has to be an intention to exploit in the future, is pleaded? You are necessarily needing to infer something which is not in the assumed pleaded facts. And the point I made a moment ago, my Lady Rose, is made by Lord Hughes in the Hunger case at paragraph 62, page 760, when he says this, he says, it follows that under these instruments, transportation amounts to trafficking if, in the case of an adult, it is accomplished by threat, force, deception, or other forms of coercion referred to, and B, only if it is undertaken with a view to exploitation in the sense defined. And then he says, her subsequent exploitation, again assuming despite the absence of findings that that is correctly so described, is no doubt evidence of a prior intent on the part of Mrs. Allen, but it is not conclusive and the tribunal has made no finding one way or the other. And that's my point. There is no assumed pleaded fact here that the intention element of Palermo is present. And can I just make this other very important point? My learned friend relies heavily on, in Hunger, paragraphs 48 to 49, where Lord Wilson refers to the ILO indicators of forced labour. And when one looks at that case, Lord Wilson then extrapolates that to be ILO indicators of trafficking. And I say that's erroneous. And my learned friend is erroneous in suggesting that that ILO indicators document are indicators of trafficking. They're indicators of servitude, they're indicators of slavery, perhaps forced labour, but not of the definition of trafficking. To elide the two is to err. In the alternative, we say on the assumption that the appellant has pleaded that she is a victim of trafficking, Article 3 of Palermo, again we say, if the appellant has pleaded that she was trafficked by the respondent into the employment relationship, this does not turn the employment claim into an action relating to any commercial activity. So now I move back to that. So let's assume she ticks the Article 3A Palermo definition. At first, we say, if the appellant has pleaded that she was trafficked by the respondent, it doesn't follow that he was engaged in a commercial activity. He hasn't set up shop. For example, there is no suggestion that pleading that the respondent operated a commercial trafficking ring on the side. Secondly, the alleged trafficking was not for personal profit of Mr. Basfar. The saving or reduction of a household expense is not a business profit. It's not generated in the course of business. It's not remuneration in a regular business operated by him over a course of time. The appellant and Calayan's reliance upon global statistics is of no effect. We also say that the employment of Miss Wong, whether that relationship came about as a result of human trafficking or not, remains an act that is incidental to and not independent of the diplomat's role. The employment of domestic servants was expressly contemplated by the VCDR, as I've said, and the drafters considered the employment claims by domestic servants would fall within the scope of diplomatic immunity, and that's in our written case at paragraph 77. Now, my lords, my lady, that is not altered by the facts leading to the employment of the domestic servant, including whether the appellant was trafficked into the employment. We also say that the appellant's case requires the court to conclude that from the fact that the human trafficking involves the alleged commodification of human beings, that therefore the respondent was engaged in a commercial activity. That, we say, simply doesn't follow. That argument would require every purchase of goods and services to fall within the 31(1)(c) definition. However, it's clear that non-payment for goods and services falls within the scope of diplomatic immunity. We also say...
I'm getting increasingly troubled about the time. I think you're essentially summarising materials that are in your case, which we have read. You don't need to feel that we're going to treat you as abandoning any part of your case which you haven't repeated orally.
I fully expected that, my lord. I'm drawing to a close on the case against Mr.
Yes, please.
Otti, and I can move swiftly to deal in short order with the interveners. Can I make this point? If the alleged trafficking is a commercial activity, and we have to identify the commercial activity, we have to identify the elements of trafficking in it, that doesn't turn the legal action brought by the claimant in the employment tribunal for wages into one that's related to that commercial activity. And I make 2 points. First, human trafficking is the process, the chain of actions from recruitment to receipt, involved in moving human beings with the intention of exploiting the victim. The wrong of human trafficking captures a different form of wrongdoing to the final exploitative treatment. And any employment subsequent to the trafficking or mistreatment during that employment subsequent to the trafficking, including an exploitative employment relationship, may be evidence that the alleged trafficker had the required prior intention to exploit, the purpose requirement, at the time of trafficking. However, the employment and the treatment of the appellant does not itself amount to human trafficking as defined. The second point I make is that any claim based on the employment and treatment and enslavement is not related to the commercial activity of trafficking. The human trafficking into the situation of exploitation forms part of the background only to the employment relationship on which the claims are based. The appellant's claims do not depend, her claims in the tribunal don't depend at all on whether the appellant was trafficked. It is of no relevance when the tribunal comes to determine a statutory employment claims at a full merits hearing, at a liability hearing, it'll be of no substantive relevance to the tribunal as to whether she's been trafficked or not. None of the claims, none of the ingredients to the causes of action touch upon trafficking. They are not, therefore, related to any commercial activity. Remember in Article 31(1)(c), it is the legal cause of action that needs to be related to the commercial activity. It's not just that the action refers to the litigation, to the cause. And further, we say the tribunal doesn't have jurisdiction. It simply doesn't have power to resolve any allegations of trafficking or liability for trafficking. It only has that power that it has been statutorily given. And you've not heard at all how it is said for a single moment. I mean, we've heard it repeatedly, but you've been taken to no authority for the proposition that an employment tribunal is empowered to make a declaration of liability for human trafficking and to compensate victims of human trafficking. What they can do is to compensate for not underpayment of wages and breaches of working time regulations and other things within its powers.
This is all in your case, Mr. Sayre.
Well, my Lord, you have it well in mind, I'm sure. In relation to Calayan, you've seen our submissions on that. I think they're pretty. They can be briefly summarised. If I spend only 5 minutes with Calayan and 5 minutes with UNSR, would that suffice, or would your Lordship prefer?
Well, I want to get on and hear your submissions about the human rights point raised by the second intervener, which is what you were given the extra hour for.
My Lord, I can do that.
Please.
With comfort, because I'm comfortable that our points in response to Calayan are compelling, not least because Mr. Otti
they're certainly there to be read.
Doesn't adopt them. Our response to the UNSR's human rights arguments can be quite briefly, in my submission, understood and accepted. The UNSR human rights submissions focus on an attempt to modify the law in line with desirable developments, as they say, instead of interpreting 31(1)(c), which is the question for this court. We set this out in our response written case at paragraph 43. The UNSR advances its attack on a basis which is not pleaded, on a basis which doesn't form a ground of appeal. And at first, the first point is, of course, that there is no basis on which to entertain it here. And I note that my learned friend Mr. Otti doesn't really advance them with any conviction. There are two prongs for the UNSR's fresh points of law taken. The first is based on Article 6 of the ECHR, and the second is based on Article 4. In relation to the Article 6 argument, there are 4 points that form the basis of our response. The first is simply this, that if one appreciates, it's the reason why at the outset, from first principles, we had to establish that diplomatic immunity is wider and stronger than state immunity, that it serves a different purpose, that it's a stronger immunity, that it has, therefore, a different legitimate aim. What you are then looking at to see whether there has been a disproportionate or whether the legitimate aim is justified in breaching or potentially breaching a Article 6 right that is engaged. You need to understand at the starting point what is the legitimate aim that is engaged. And if you're starting with the legitimate aims of state immunity, then you're at the wrong first base. You're on a different pitch. You're not in the pitch of looking at a diplomatic immunity case in the context of human rights. You're looking at a state immunity case in the context of human rights. And so at first base, we say that they're way off the mark. I've already taken you to the different rationales and the special vulnerability of diplomatic agents, and it's set out in our supplementary case at paragraphs 11 to 9. And can I ask you to take note of our, is this in the supplementary submission? In our response submissions, paragraphs 14 to 18 also, in particular. So that's
There's a degree of circularity about the Article 6 point, because the interference would have to be in accordance with the law, and in accordance with the law brings us straight back to the Article 31 C exception. So one has to find out what the exception is, first of all, in order to determine whether it's in accordance with the law.
Yes.
And so, and also, the legitimate aim would be the legitimate aim of the exception. And,
correct.
So, again, it's a circular argument. Once you establish both of those things, the proportionality would be relatively straightforward. But
yes, but it's not.
But whether there is a breach of Article 6 would depend upon what the proper interpretation of the diplomatic immunity was.
Yes, entirely agree. And there is an argument to say that Article 6 is not even engaged.
Yeah.
And you have that point, that the United Kingdom has no jurisdiction to give or to deny in the first place. Look at Jones for Lord Bingham at paragraph 14 and Lord Hoffman at 64 in Jones, pages 2351 and 2366, and that's in our response case at paragraph 20. And that's the second point I make here. The third of the 4 points in response to the Article 6 argument is that when you then look at the proper legitimate aim, and my Lord, Lord Stevens, absolutely right, but you need to look at in order to understand the legitimate aim of the exception, you need to start off with the legitimate aim of diplomatic immunity in the first place and the scope of that. So they have to be dealt with together. The Diplomatic Privileges Act 1964 has a legitimate aim, its compliance with mandatory rules of international law to prevent hindering diplomatic functions, and therefore the mission. And that is, we say on the authorities, a proportionate means of achieving that aim. Implementation of mandatory rules of international law cannot in principle be a disproportionate restriction on the right of access to the courts. And the authority for that proposition is Fogarty. Fogarty, at page 176, paragraph 36.
But presumably on both Article 4 and Article 6, you rely on the Court of Appeal decision in Reyes, do you? On both these points?
On the Article 4 point. And the Article 6 and the Article point, yes I do. That's a neat way of short-circuiting, and that's why I simply say there's 4 points, and you'll have them. And the fourth point, and actually, if you wanted to confirm the Fogarty approach as the correct approach, you can understand why there's a particular approach, because the reason why state immunity became eroded in the context of employment contracts, as is evident from the Kudak case and the Sabah El-Lil case, is precisely because there had been recognition movement at the international level, treaty level, and there had been erosion of immunity, of state immunity, for employment contracts. The fourth point, and that brings me neatly on to the fourth point, and that is this, that there are no developments in diplomatic immunity similar to that had occurred in state immunity in the state immunity cases where Article 6 is considered, namely the 2004 UN Convention on State Immunity. And Mr. Justice Langstaff makes this point very well in Reyes, in the EAT, at page 733, paragraph 35, if I could briefly take you to that. Can I say, not only do I adopt Lord Dyson's approach in the Court of Appeal, but Mr. Justice Langstaff also quite articulates the Article 6 and Article 4 points very well. and persuasively and of assistance to our case. At page 733, paragraph 35, in dealing with this point, he observes as follows. Whereas state immunity was subject to restrictions most recently agreed by international convention in 2004, that was not the case where diplomatic immunity was concerned. It was the 2004 convention which persuaded the European Court of Human Rights to hold that Article 6 had been breached in the state immunity cases of Kudak and Sabah el-Lil. There was no similar development where diplomatic immunity was concerned, where the Vienna Convention remained unaffected. The principle of Fogarty was that, absent such a development, the aims pursued by the conferment of state immunity justified a restriction of access to court. Since there was no modification of the convention applicable to diplomatic immunity, as had been the case with state immunity, and, a second basis he adds, and since diplomatic immunity was wider reaching than state immunity, there was no warrant for holding that the restriction of access in the present case was disproportionate. And we deal with this, and therefore we conclude on this, the Article 6 response, we say there is no basis for developing diplomatic immunity to follow developments or to track developments in state immunity. They're dealing with different matters and have a different juridical basis, and we deal with that in our response at paragraphs 24 to 25. So, my lords, those are the four pillars of my defence to the UNSR's Article 6 attack. And it's telling that my learned friend Mr. Rossi doesn't take these points, because I think he recognises the force of our submissions on these. Article 4. The UNSR's Article 4 argument, well, it's important, we say here, to emphasise that it's the state's positive obligations that are invoked. These are not absolute, the state's positive obligations. See E and Chief Constable of the RUC, per Baroness Hale, at paragraph 10, and Lord Carswell at paragraph 45. That's at pages 40 and 49, respectively, in our Respondent Supplementary Authorities Bundle, and that has, I'm hoping, worked its way over to this court.
It has.
There are 4 points here, too, that we make in response briefly. The first, the tribunal does not have jurisdiction to determine whether the facts amount to human trafficking, so that Article 4 is engaged. I've made the points by reference to the earlier arguments. But here again, Mr. Justice Langstaff assists, because at page 737, paragraph 54, and the point we're making in a sense is that breach of Article 4 is not a freestanding employment tribunal claim that gives rise to declaration or compensation. At paragraph 54, he observes, in my judgment, the place to begin is in the rights. Actually, we start at 53. Mr. Setti's response is first that neither claimant asserted a breach of Article 4 ECHR in her originating application. Second, that the United Kingdom's obligations were satisfied by the enactment of Section 71 of the Coroners and Justice Act 2009, which criminalised slavery, servitude and forced or compulsory labour. Third, that the tribunal's jurisdiction is statutory and does not extend to the investigation of alleged trafficking, for which in any event it is ill-equipped, but only to resolving those disputes within its statutory remit. In my judgment, the place to begin is in the rights which are asserted in the claims. They are not expressly based on the claimants being trafficked. They are complaints that their employment rights have been breached. Employment tribunals have jurisdiction subject only to the existence of a procedural bar to resolve such claims. They do not have any jurisdiction to resolve any freestanding complaint that there has been ill treatment of an employee in some respect, which is not germane to those claims. Such a complaint may, depending on its nature, give rise to other claims before the common law or administrative courts, but only claims allocated by statute to an employment tribunal may be determined by it. An overlap of claims, an expression relied on by Mr. Luckhurst, is not the same as a coincidence of them. They are not coterminous. To the extent the trafficking allegation goes beyond the employment claims, a tribunal has no power and therefore no right to consider them. A claim for the payment of contractual or minimum wage and for the compensation for race discrimination is within the jurisdiction of the tribunal. Wider trafficking claims are not asserted in the present case. There would be no basis to hear them. My Lord, we deal with this in our supplementary written case at paragraph 29. The second of the 4 responses is this: the positive obligations are not absolute. The 1964 DPA pursues a legitimate aim, and it is in principle a proportionate means of achieving that aim. See the Attorney General and Barnett authority at paragraphs 99 and 107. That's pages 1690 to 1691. And see also Baroness Hale and Lord Carswell at paragraphs 10 and 45 in E and Chief Constable of the RUC, pages 40 and 49 respectively.
So page reference, please.
40 and 49 of E and Chief Constable of the RUC. Yes, 40 and 49 is the electronic reference in the supplementary bundle.
Thank you very much indeed. Thank you. Sorry.
We deal with this now in our response case at 31 to 32. The third point is this: that there are measures that the UK can take to protect victims of trafficking and meet its positive obligations that are consistent with and provided for within the VCDR, as I've already set out. The DPA 1964 therefore does not necessarily breach Article 4, requiring some reinterpretation or declaration of incompatibility, and that's set out in detail in our response written case at 34 to 35. The fourth and last response is this: if there is a conflict, there is no reason, with Article 4 that is, there is no reason why the VCDR must be read down subject to the state's positive obligations, and not the other way around. See our written case at 36 to 39, our response that is. The UNSR's submission is misconceived for three reasons, And those 3 reasons are as follows, and this is really the last point I make in response. Firstly, the European Court of Human Rights has recognised on numerous occasions that the European Convention is to be read in the light of other rules of international law. It cannot be right that the ECHR requires states to disapply diplomatic immunity in the case of a diplomatic agent committing the criminal offence of trafficking in contravention of the MSA 2015, in respect of which a diplomatic agent undoubtedly retains immunity whilst in position. We'll deal with that at our response, paragraph 37. The second subpoint is this: that diplomatic immunity was a customary rule of international law at the time of the enactment of each of the human rights instruments relied upon by the second intervener, none of which explicitly provided for reconciliation with diplomatic immunity, and that we dealt with in our written response, paragraph 38. Thirdly and lastly, it is for the ECHR as a living instrument consistently read in light of and subject to other relevant rules of international law to be read as being subject to the VCDR. And here I quote from Attorney General and Barnett, paragraph 85 at page 1685, where it was observed that the VCDR cannot develop in that way. To the contrary, its text as negotiated and agreed is absolutely fundamental, without developments unless agreed by the state parties, without comments by a sponsoring body or national qualifications or judgments, however learned. And we deal with that last response ground at paragraph 39 of our response. My Lord, those are my responses to the interveners' written cases. One last observation, perhaps, which I have not stressed so far, it is in our written case, but that is this, that there may be a perceived tension between international obligations of trafficking and pre-existing international obligations of diplomatic immunity. Tension does not mean a conflict of law. Diplomatic immunity is a procedural immunity from suit. It's a procedural immunity from the jurisdiction of a receiving state's courts. It does not, therefore, even conflict with substantive rights in that sense. It's a procedural bar, not a substantive bar, and that fundamental principle also needs to be, we say, appreciated as a fundamental issue here when one is even considering whether there is true conflict on this appeal. I won't even begin to summarise my submission. I simply say that unless I can be of any further assistance to my lady and my lords, those are my submissions.
Well, thank you, Mr. Sethi. We've subjected you to a barrage of requests for assistance, all of which you've dealt with. We've also finished half an hour ahead. Now, Mr. Otti, that means that unless there was some aspect of your reply that you planned to revise over the lunchtime adjournment, we could hear your reply now.
The tantalising prospect of finishing at 1 o'clock.
Well, I'm saying everybody the time and cost of attending in the afternoon.
I'm certainly content to start now, my lord. I just wanted to mention two matters that arose out of this morning's submissions, which we were proposing over the short adjournment, if Mr. Sethi was still on his feet, to attempt to assist the court on. Until his submissions, we hadn't appreciated there was any disagreement between us as to the meaning of harbouring. There is a decision of Mr. Justice Cranston from 2016 which contains the following passage: "Harbouring is not an everyday concept, but I accept that it includes accommodating or holding a person at the place of exploitation or at a place prior to the exploitation." Now, I wasn't proposing to say any more about that authority than that, but if we have liberty to put that in at the conclusion of my submissions or even during them, I'd be grateful.
What's the name of the case?
It's R brackets BG against the Secretary of State for the Home Department, and the reference, the neutral citation number is 2016 EWHC 786 admin. And the second matter, my lord, related to the exchanges between Mr. Sethi and Lord Stevens, and to some extent Lord Leggett, on what may be a bit of an arid point, the pleading point. But as a matter of record, it is the case that Reynolds Porter Chamberlain for Mr. Basfar sought the exclusion of a witness statement from my client. And it is also the case that that witness statement contained a host of extremely serious allegations. Now, again, I'll give a flavour for those during my...
Well, were they in fact excluded?
They were excluded on the basis of the agreed premise that my client was to be treated as a victim of international trafficking.
I think we're concerned, if you like, with the agreed premise rather than with opening up what was excluded on the assumption that there's been some fundamental breach of the agreed premise.
My lord, yes, but what I was concerned by was the suggestion that, as Mr. Sethi, as I understood it, put it, so far as we're aware, there could be no allegations about mistreatment in Saudi Arabia.
Well,
now,
subject to those next to me, I don't think we're going to be assisted by being shown what you would have shown the Employment Tribunal if you hadn't
had the agreed premise.
It wasn't admitted.
What we're concerned with is the terms of the agreed premise.
Yes, it wasn't admitted because it wasn't necessary because of the agreed premise.
Yes.
And well, in that case, I just wanted to mention that, my lord, because as a matter of record, perhaps didn't come across entirely clearly that there had been an attempt to exclude the evidence, a successful attempt to exclude the evidence on that basis. So subject to that, my lord, I'll press on, if I may.
Yes, please.
And I'd like to start by addressing some of the particular points which arose during Mr. Sethi's submissions yesterday afternoon, and to some extent will return to today, not entirely in the order in which they arose, but in what appear to us perhaps to be questions of most importance or greater importance. And the first concerned your lordship's question about the particular rationale for the Article 31 exceptions, and Mr. Sethi's response by reference to what Lord Dyson had to say in paragraph 16 of the Court of Appeal's judgment in Reyes at EF page 833. Now, we respectfully submit that passage assists Miss Wong, not Mr. Basfar. There is no sense in which a diplomat who engages in international trafficking and subjects an individual to modern slavery is doing what he is sent to the receiving state to do. In addition, as I submitted yesterday in response to an earlier question from my lord, the exception in Article 31(1)(c is, we say, also justified because the diplomat has chosen to engage in a particular activity. He has deliberately taken a plunge into the waters with the intent of extracting financial gain for an ongoing period. And again on rationale, and again as I mentioned yesterday, and further supporting Mr. Wong's case, we also have Mr. Justice Law's views as to what underpinned, or underlay, as he put it, Article 31. He said in terms at EF page 785 that the divide between acts done de jure imperii and acts done de jure gestionis, reflected in state immunity, as he put it, underlies the exceptions to diplomatic immunity constituted by subparagraphs A to C of Article 31.1 of the VCDR. Now, if that is right, that supports rather than undermines the submission that at least some material assistance may be derived from the law of state immunity, and supports Lord Wilson's view at paragraph 65 of his judgment that it's difficult to see why such a radically different approach, as Lord Sumption contended for, should apply as between one and the other. The second particular point from yesterday afternoon that I wanted to address was what was, I think, described as the potentially significant narrowing of the issue in this case, which ultimately appeared to rest on Mr. Sethi's suggested distinction between the diplomat who earns a profit and makes a financial gain and the diplomat who saves costs and makes a financial gain. And that is, we say, a distinction which is not only a very fine one, it is one which simply has no place in the assumed context of human trafficking and modern slavery. And I'd like to draw attention to a series of particular passages in the materials before the court which make good that point, if I may. Firstly, the ILO's 2014 report, Profits and Poverty, at EF 5122, which I also drew attention to in opening the appeal, and which is referred to in our printed case at 43.3, and particularly the following passages. Firstly, EF 5138, Chapter 2 onwards, estimating the profits of forced labour, and at the end of the first paragraph on that page, referring to the fact that while victims of forced labour often spent less than 6 months in such conditions, during such time employers could make significant profits by exacting forced labour. And then at 5142, in the first paragraph just below the table, the ILO estimate that I referred to, that nearly $8 billion of illegal profits are generated in domestic work alone, where employers use threats and coercion to pay no or low wages. EF page 515, with the graph showing average annual profits of $2,300 per victim per year in the domestic work sector. EF page 5154, under the heading Profits from Forced Labour in Domestic Work, where the figure of $8 billion is returned to, and where in the second paragraph the ILO makes the following observation.
Sorry, is the calculation of profit done by calculating the employment costs saved, or is it the profit from the business that people are forced to undertake?
It's the former, my lord. It's the profits through saved payments.
Right.
And then in on page 5154, I refer to the 8 billion figure again, and then in the second paragraph, the ILO makes the following observation. As noted in the ILO 2005 working paper, domestic services create an economic value added, and therefore the savings made by the employer on expenditures count as profits. The stolen wages consist of a combination of monthly wages, which are lower than they should be, abusive deductions for housing and food, and illegal deductions for recruitment costs, deductions of the kind that perhaps featured in Lady Rose's intervention yesterday. And then, and I'll show you the 2005 working paper in a moment, and then we have the rather chilling, but we say powerful and informative conclusions of the ILO at EF page 5174, and we emphasise particularly the second and fifth paragraph on that page, and ask the court to note in the fifth paragraph the observation about unscrupulous employers reaping huge profits.
Sorry, which page?
5174, my lord.
174, thank you.
Now, it's perhaps worth emphasising here just what the ILO is. It is the only tripartite United Nations agency. It brings together governments, employers, and workers of 187 member states. It is also one of the oldest international agencies. It was created in 1919 as part of the Treaty of Versailles. Part 13 of that treaty created the ILO with its express purposes, including the promotion of humane conditions of labour. And both the United Kingdom and Saudi Arabia are, of course, members of it. The UK joining at the outset in 1919, Saudi Arabia in 1976. Going to another ILO document, the 2005 paper I mentioned, that is at EF pages 4813 to 4814. And the key point here is on page 4814 at footnote 15 at the bottom of the page, where the ILO is actually addressing what is in essence Mr. Sethi's argument. And it, for its part, expresses the clear view that savings achieved from imposing forced labour on domestic workers are savings on expenditure which count as profits. Now, moving to the domestic context for a moment, EF 4352 has extracts from a report produced by Baroness Butler-Sloss as part of the 2013 Modern Slavery Bill, the Modern Slavery Bill Evidence Review. And at EF 4367, in the second paragraph below the quotation, the panel said this: most forms of modern slavery today function for the same purpose as slavery throughout history, to maximise profit by minimising or eliminating the cost of labour. It's of course vulgar to use such terms when describing victims, but we must address the issue from an economic point of view. Profits drive the trade. Fourthly, and similarly, again from another domestic perspective, at EF 5188, we have the Australian Government National Action Plan to combat human trafficking and slavery.
Sorry, I missed the page reference.
EF 5188, my lord.
Thank you very much indeed. Thank you.
And the material passage here is under the heading What Human Trafficking and Slavery Are Not, and the distinction is being drawn with migrant smuggling. And I emphasise, 5189, is the material passage. I emphasise here, human traffickers are motivated by the prospect of profiting from the exploitation of their victims once they reach their destination. And in human trafficking cases, profits are derived from exploitation. So this all emphasises, we say, the absolutely core element of human trafficking, exploitation, and the absolutely core motive for traffickers, profit from that exploitation. And it shows, we say, why Lord Wilson was correct at paragraph 62 of his judgment, that it is the motive to exploit the victim that drives the whole activity. And it shows with respect that Lord Sumption misunderstands the essence of trafficking when he characterises the person who gains from the labour of the victim as some sort of mere end user who is remote from the core of the activity. They are integral to it.
Isn't your claim really for forced labour, Mr. Otti? Because what your client is claiming is wages you should have been paid. The answer to that is diplomatic immunity, to which you respond, no, it's a commercial activity. But the profit is actually, the commercial activity, which is the subject of your client's claim, is her servitude, isn't it, in this country? The trafficking which brought her here is not the subject matter of the claim.
It's not what triggers what would trigger the award of damages or compensation. But the question for the court is, does the claim relate to commercial activity engaged in by the diplomat? And if the question is posed as in those generalised terms, and then adopting Lord Wilson at paragraph 56, yes, it embraces domestic servitude, and domestic servitude is part of the definition of human trafficking. But to say that
I'm not at the moment convinced that the end result of the movement, the servitude in which the person is then kept, is part of the trafficking. Seems to me, as reflected, for example, in the Australian case and the English definition and the Act and so on, that the trafficking ends when the person reaches their destination. Part of it is that they're going to be, part of the definition is that they're taken there for the purpose of being used for forced labour when they get there.
Well, we would say...
We actually then transition into forced labour, strictly, it seems to me.
That would be right, my lord, if the definition of trafficking stopped with transportation and didn't...
With receipt.
I'm sorry, my lord?
With receipt, not
with
transportation.
Receipt, and it embraces harbouring, my lord, as well. So the definition of trafficking embraces the full temporal span from the moment of recruitment in Saudi Arabia, transportation to this country, treatment in this country, throughout the period of what my lord rightly characterises as domestic servitude.
Well, I'm not sure about that. The harbouring is before the receipt.
Well, that's where we would say...
Look at what Justice Cranston said, but...
I mean, it comes in the description before the receipt, and the description in the protocol appears to be a description in point of consecutive time of a series of activities.
I see that that's one interpretation of it, my lord. And
it is a different way of asking the same question. Suppose Miss Wong had been recruited by Mr. Basfar from an entirely respectable domestic workers' agency operating in England, with which she'd signed up, and then they treated her in the way in which it's alleged she was treated in her ET claim. Do you say that there would or wouldn't be immunity from that claim?
There would not be immunity because there would be harbouring going on.
If Miss Wong had been living here for since a child, she had worked doing domestic work. She signed up with a cleaning agency, and she went to work for the Respondent, and suddenly she's faced with these terrible conditions, and she manages to escape and brings the claim that she's currently brought. So there's no question of her being trafficked at any stage. Would there be immunity or not?
Well, if the summary of the premise is accurate, my lady, if there's no question of her being trafficked, then on my case there wouldn't be immunity. But I respectfully disagree with you about the solidity of the premise once one understands the international definition of trafficking.
Sorry, there wouldn't be immunity even if she'd not been trafficked.
No, my lady, our case, I accept, rests upon the international definition of trafficking being met. That is what this appeal is about.
Yes, it's not a forced labour case.
It's not a forced labour case. It's an international definition of trafficking case. And it is a question of construing what commercial activity means. And the concept of forced labour and slavery in a wider sense comes in because the court has to undertake this interpretive exercise of determining what commercial activity means. And if the starting point is that in 1961, the answer to the question, would involvement in the slave trade by a diplomat be commercial activity covered by the exception? And the answer would be, of course, yes. Then when we come to 2021, and we're asking the question, is modern slavery within that definition? The answer must also be yes, we say. But if the question being put to me is the same question essentially as Lord Sumption put to me back in Reyes, would a diplomat who buys a slave be engaging in commercial activity? My answer would be yes.
No, it's not the same question at all.
But where I would respectfully take issue, at least with the theme underlying my ladyship's question, is in submitting that it overlooks the wide and disjunctive nature of the definition of trafficking, which, to go back to it, we have at paragraph 8, in many places, of course, paragraph 8 of our printed case, EF 321. Trafficking in persons shall mean the recruitment, transportation, transfer, harbouring, or receipt of persons. So you don't have to have the whole chain satisfied in order for the definition to be met. In fact, I'm sorry, Mark.
The trouble with receipt is that it's the antithesis of a continuous activity, or maybe, whereas exposing somebody to 3 years of forced labour obviously has an element of continuity about it.
Well, my lord, yes, and that's why, on the facts of this case, on the assumed facts of this case, we say each of these elements is met, in fact. It's not just receipt. And we say that's borne out by any sensible inference from the pleaded facts. And we rely, of course, on what we submit to be an accurate description of the definition of harbouring too. So
I understand that, but if the matters for which your client is seeking compensation from a tribunal are those matters which only occur once her employment commences, in the UK that is, then, and if receipt, as it were, is what happens at 9 o'clock on the Monday morning and the employment thereafter commences, what about Mr. Sethi's point that there's a disconnect between your case that you were trafficked and the matters in respect of which you're seeking compensation from the tribunal?
Well, there, perhaps, there, ironically, perhaps we're in the strongest position in terms of all the authorities that have gone before, because Lord Dyson considered it an overly technical notion to suggest that our claims did not relate to trafficking just because the cause of action was different. And he cited Hounger.
Well, hold on a minute. Was the employee in the Reyes case trafficked by the defendant or just employed by the defendant? Well, that begs the question of what trafficking means. What I mean is, are the steps anterior to the commencement of the UK employment upon which your client relies matched in the Reyes case?
Essentially, yes. It's not phrased that way, and that's an aspect of, but you'll see, in fact, in the ET and the EAT in this case, it's found that there's no material distinction in terms of the actual facts as between the two contexts. Now, it may be there was a particular focus in Reyes, particularly in the Court of Appeal, on the act of employment because it was heard in the same week before the same panel with the same advocates as Ben Caboose, where that was the issue, bare employment only. But on this question, which is, as I understand it, and on the basis of the Diplomatic Relations Convention, the key question, does the action relate to trafficking? And the submission made against me is it can't be said to relate to trafficking because your causes of action are not for trafficking per se. Now, that was held to be an overly technical approach by Lord Dyson in the Court of Appeal in Reyes, and it was and he cited Hounger in support of that. And the reference that you had earlier from Mr. Sethi to Mr. Justice Langstaff reaching a different view in the EAT doesn't survive Hounger. Hounger came out between the EAT and the Court of Appeal in Reyes.
This may be another way of asking Lady Rose's question, but if you would you say that if somebody had been subjected to forced labour in this by a diplomat in this country, but not trafficked here by the trafficked here, that would be within or without the diplomatic immunity? Because it seems to me that your argument is really based on the exploitation, that is the commercial activity. The exploitation by forced labour or slavery or something similar to it.
I would say, my lord, I'm sorry, didn't understand the thrust of the question adequately earlier, but I would say that that would be within the definition.
Sorry,
You mean within the definition of commercial activity?
Of commercial activity, yes.
Yeah.
Sorry, so within the exception.
Yeah.
But I don't need to get into that, I say, on a proper analysis of the facts of this case, because we are, on any view, we say, entitled to proceed, and that's the premise for the debate, on the basis that the international definition of trafficking is met, with that as one of the component elements, domestic servitude within it.
So what makes it just looking at the forced labour without trafficking, which was my scenario, that she's a person living here who signs up and is then unknown to the cleaning agency, is then badly exploited. You say that that would amount to commercial activity on the part of the employer because they are making money from her by underpaying her.
It's more than that, my lady, and this is back to the question that your ladyship asked me yesterday about what's the difference between this context and a minimum wage, a pure paying below the minimum wage context. And the extra component that either the forced labour context or the trafficking context brings is the confinement of that person and the inevitable extraction of value, which treats the person in that context as a commodity. As I put it yesterday, they don't have the option of walking away. They are being treated like an object from which value can be extracted on an ongoing basis.
That appears to me to be accord with the Van der Mussel against Belgium case, and also Ransef, where forced or compulsory labour, there must be some physical or mental constraint as well as some overriding of the person's will, and all work or service which is exacted from any person under the menace of any penalty and for which the person has not offered himself voluntarily. So your mere underpayment to a person doesn't meet that definition.
It doesn't, my lord, no.
And also the concept of relating to trafficking. The claim in the tribunal, if it doesn't relate to trafficking, well, there may be other common law remedies for being trafficked in other courts. And so you're not confined to the tribunal.
No, my lord, we're not. But the words relating to are entirely broad enough to embrace the scenario that we are presented with here, where the factual allegations underpinning the individual statutory causes of action constitute commercial activity, trafficking, or on this different and narrower hypothesis, forced labour. And as I say, that much, having not had the most receptive audience in the Court of Appeal first time around in Reyes, that much we were able to persuade Lord Dyson of, by reference, amongst other matters, to Haunger and Lord Wilson and Haunger. So it is, we respectfully submit, not a difficult bar to clear, the relating to part.
Do you say it's satisfied because the employment was a result of trafficking?
The employment was the result of trafficking, and the individual causes of action which are being pursued are based upon acts of trafficking too.
Or what are the acts of trafficking?
Well, the harbouring, the confinement, and the exploitation. And if making someone work the hours that are being worked and being confined to the home and so forth, all of which trigger the domestic employment law remedies, are not acts of trafficking, then it's a difficult submission, I accept, but they manifestly are once one looks at the international definition. So there's no difficulty with it either as a matter of relating back to what's happened before or relating to the entire run of ongoing exploitation that has occurred during the period of notional employment. I see the time, my Lord.
Yes, well, we've taken up the whole of your time with questions, virtually, Mr. Royce. I'm not going to be uber beastly and rule you out from saying a little more at 2 o'clock if you think you need to.
I would like to trespass upon the patience of the court and reserve the right to do so, if I may, my Lord.
We probably don't need the full half hour, though.
No, you won't need the full half hour.
2 o'clock.